Right, today I'm going to take a little bit of a different spin and look back in time. And we're looking at the state of New South Wales versus Kiskonin 2021. I'm just going to read the text. We'll comment as we go. It's going to be made up of a lot of different videos, this, because it's going to take some time to go through. I guess we attention this to the Attorney General, both of New South Wales and of Australia, and likely all the other Attorney Generals of State and Territory, because this relates to your little knock on the door from the United Nations. So, Supreme Court case, New South Wales, medium neutral citation, State of New South Wales versus Kiskonin, preliminary, 2021, NSWSC 915. Hearing dates, 21st of July 2021, date of orders, 27th of July 2021, decision date, 27th of July 2021. So we can see this case took one sitting in a courtroom, jurisdiction in common law, the Court of Common Law of New South Wales, before Justice Lonergan. Justice Julia Lonergan has been sitting in this position at the Supreme Court for a number of years. Decision. Amended summons dismissed. Number 2. Plaintiff to pay the defendant's costs. Catch words: high risk offenders, preliminary hearing, whether interim supervision order should be made, whether matters alleged would, if proved, justify an ESO, whether offender poses an unacceptable risk of committing a serious terrorism offence. Application refused. Legislation cited: Criminal Code, Commonwealth, so it'd be the Criminal Code 1995. Firearms Act 1996, New South Wales. Terrorism, High Risk Offenders Act 2017, New South Wales. Cases cited: Minister for Home Affairs versus Ben Breaker, 2021, 388, ALR 1, 2021, HCA 4. State of New South Wales versus Fayad, preliminary, 2020, New South Wales, SC 1681. Category: Principal Judgment. Parties: State of New South Wales, the plaintiff, and Kiskonin, the defendant. Representation: Counsel: J. Emmett, SC / T. Epstein, plaintiff; M. Johnston, SC / E.S. Kirkyasharian / S.J. Young, defendant. Solicitors: Crown Solicitor's Office, New South Wales, plaintiff; Ryan Patent Lee, defendant. File numbers: 2021 /002 01054. Publication restriction: nil. Choose an item. So we've laid out a court matter that has occurred last year. We can see that the matters have been dismissed. We can see that applications were refused, and we can also see that orders weren't justifiable. This is just in the leading catchwords that will appear throughout the case. Right, so as we carry on, this case has a lot of backstory which we'll fill in as we go. This starts to now look into the case. Choose an item. Judgment. 1. The plaintiff, the State of New South Wales, brings proceedings against K, the defendant, pursuant to the High Risk Offenders Act 2017 New South Wales, the Act, in inverted commas, for an interim supervision order, an ISO, under S27 of the Act for 28 days, with a view to obtaining an extended supervision order for 3 years on specific conditions. Ancillary orders are sought for the appointment of 2 psychiatrists or psychologists under Section 24I of the Act, and that the defendant be directed to comply with a series of conditions, 55 in number, during the period of the ISO. These 55 conditions aren't listed in the report here, but they obviously can't use a phone, can't use the internet, can't use this, have to wear the right coloured undies, have to use the right type of toilet paper. Like that, they would be pretty stringent, and given that they would be wanted to be followed for 3 years, the defendant opposes the imposition of an ISO or ESO. So we have a plaintiff claim, pretty seriously strong one, and the defendant saying no, that's not justifiable. The summons seeking these orders was dated the 12th of July 2021 and was filed on the 13th of July 2021 in the 10 days prior to this court. An amended summons was filed in the court with leave on the 21st of July 2021, which would be this date. The defendant is due for release at midnight on the 29th of July 2021. So the police have attempted at the very last days of a sentence to jump in on the gun to further impact the life of someone over some very spurious and stupid claims that we're about to go through. This all started in a very largely disrespectful way, with a total ignorance of the facts that are on the table, and it just squarely belongs in the Attorney General of New South Wales' hands when we look at what we're about to go through. The legislation. 5. The requirements for making an ESO are set out in SS 20 and 21 of the Act. 20. Supreme Court may make extended supervision orders against eligible offenders if unacceptable risk. The Supreme Court may make an order for the supervision in the community of an eligible offender called an extended supervision order if A. the offender is in custody and under supervision, or was in custody or under supervision at the time the original application for the order was filed. You can see why the police have attempted to jump the gun, so to speak. I. While serving a sentence of imprisonment for New South Wales indictable offence, or under an existing interim supervision order, extended supervision order, interim detention order, or continuing detention order. We can see through the toy gun that the police have again jumped the gun. B. An application for the order is made in accordance with this part, and C. The Supreme Court is satisfied that the offender is in any of the following: a convicted New South Wales terrorist offender, a convicted New South Wales underlying terrorism offender, a convicted New South Wales terrorism activity offender, and D. The Supreme Court is satisfied to a high degree of probability that the offender poses an unacceptable risk of committing serious terrorism offence if not kept under supervision under the order. So this already puts the police's mindset in a certain framework wherein they have an objective to attack. But they've jumped in at the last minute to attempt to impact someone with some seriously harsh conditions and attempt to put that person through psychiatric assessment. And this is a large key point of where we go down this little rabbit hole that we're about to venture into. Following on from previous episode, we were looking at the requirements for making an ESO set out in section 20 of the Act. We're going to follow on with section 21 now. Determination of risk. For the purposes of this part, the Supreme Court is not required to determine that the risk of an eligible offender committing serious terrorism offence is more likely than not in order to determine that there is an unacceptable risk of the offender committing such an offence. It's a bit of a mouthful, but let's have a look at it. For the purposes of this part, the previous part, section 20, the Supreme Court is not required to determine that the risk of an eligible offender committing a serious offence is more likely than not in order to determine that there is an unacceptable risk of the offender committing such an offence. So just saying that they're going to commit an offence, or even having the belief that that may or may not be true, doesn't determine in the court's eyes, or doesn't have to be used in the court's eyes, to make that assessment and determine whether to apply the ESO or not. The court doesn't know beforehand, when the application is being asked for, the state of the offender. So the court is at liberty to make a decision based on what's in front of them, basically. Section 6. Section 4 of the Act defines a serious terrorism offence as an offence against Part 5.3 of the Commonwealth Criminal Code for which the maximum penalty is 7 or more years of imprisonment. So this is the Criminal Code 1995. I wouldn't call it the Commonwealth Criminal Code because it's codified law of the Crimes Act 1914. 7. Section 6 and 7 deal with the persons to whom the Act can apply. Section 7 defines an eligible offender as 7. Eligible offender. In this Act, an eligible offender is a person who is 18 years or older, serving or continuing to be supervised or detained under this Act after serving a sentence of imprisonment for a New South Wales indictable offence. 8. Section 6 defines the words serving a sentence of imprisonment. 6. Serving sentence of imprisonment. In this Act, a person is serving a sentence of imprisonment for an offence if A. the person is serving a sentence of imprisonment for the offence by way of full-time detention, or B. the person is on parole in respect of the offence. 9. The state says that for the purposes of Section 20C of the Act, the defendant is a convicted New South Wales terrorism activity offender as defined in Section 10 of the Act, relevantly as follows. Section 10, convicted New South Wales terrorism activity offender. I. In this Act, an eligible offender is a convicted New South Wales terrorism activity offender if the offender is serving or is continuing to be supervised or detained under this Act after serving a sentence of imprisonment for a New South Wales indictable offence, the offender's offence, and any of the following apply in respect of the offender. So there must already be within the framework of this terrorism activity to have the following apply. Can't just turn around and point fingers and then say make this apply if anybody hasn't acted in the way of the Act previous to making this accusation. C. The offender, I, is making or has previously made any statement or is carrying out or has previously carried out any activity advocating support for any terrorist act or violent extremism, or 2, has or previously had any personal or business association or other affiliation with any person, group of persons, or organisation that is or was advocating support for any terrorism act or violent extremism. So you would have to kind of be linked to a known terrorist organisation. And that's what is being pushed here in that trying to frame Australian people as terrorists to their own state. And this is being done by New South Wales Police, the plaintiff, on behalf of the state of New South Wales, the plaintiff, and this is the legislation that's involved in the plaintiff, the police, and the state of New South Wales application against someone's beliefs. The offender at C2 has or previously had any person or business association or other affiliation with any person, group of persons, or organisation that is or was advocating support for any terrorist act or violent extremism. They are trying to frame Australians in a manner that you can see as we move forward becomes quite farcical, but then turns the shoe onto the other foot. We'll have to go through this in parts, obviously, because this is a large document. But we can see how we're getting to a very hardcore level of legislation when it's the police that are protecting the state. It's the state of New South Wales versus an offender that committed what offences exactly is more to the question, because that should never have led to where we're going now. So you can appreciate that the depth that this is when you consider that the United Nations knocked on the door of one of these facilities and was denied access. And that's something that we're going to have to venture into as we go through what is now defined as publishable court material that forms precedents to a whole bunch of other stuff. Well, what we can see from up to now is a threat to life or limb is really the cause here. It's all about life or limb, really. It's the threat to harm or injury of another, It's failure in defense of self and other and property. Terrorism acts tend to be acts that are designed to harm, damage property, life or limb, cause a person's death, cause them to lose their leg, cause them to go through property damage, burn their house down. That kind of thing is defined as an act of terrorism. So is it okay for the state to do these things? That's the dark line in the sand that everyone wants to ignore. Is what's the state's responsibility in these matters? Okay, continuing on from part 2. We talked about how a terrorism act is an act designed to cause injury to life or limb, take someone's life, cause them permanent harm, or to cause an act of infrastructure damage. Burn someone's house down could be considered to be a terrorist act. Continue down the list. As we can see from the previous episode, endangers a person's life other than the life of the person taking the action. So suicide comes under a different bracket of law. Creates a serious risk to the health or safety of the public or a section of the public, or seriously interferes with, seriously disrupts or destroys an electronic system, including but not limited to an information system or a telecommunications system or a financial system or a system used for the delivery of essential government services or a system used for or by an essential public utility or a system used for or by a transport system. This covers a lot more than just the government. And this would also cover government employees that would intend to cause information system damage or telecommunications systems damage. So it works both ways. An action falls within this subsection of it. A is an advocacy, protest, dissent, or industrial action, and B is not intended to cause serious harm, that is physical harm to a person, or to cause a person's death, or to endanger the life of a person other than the person taking the action, or to create serious risk to the health or safety of the public or section of the public. An action of the act of terrorism falls within this subsection if it is not intended to cause serious harm, that is physical harm to a person, or it doesn't make sense. It's out of context. You've just repeated yourself from section 2 and then flipped it on its head 180 for section 3, meaning that both sides of the scales are considered to be terrorists. How does that work? Is advocacy, protest, dissent, or industrial action, and it tends to cover protests. This is where they've turned your protests against what their actions are into terrorism against the state. So this is the state writing legislation for its own protection, basically. That you can't be part of an advocacy group, you can't protest or show any form of dissent or industrial action like a walkout or a boycott. Or so section 3 is very weird in that it's turned anybody that wants to stand up and have a voice against the state into a terrorist that would be someone that causes a terrorist act of harm to property, life or limb. Made it very difficult for anybody to say anything against the state. And then, as you'll see, they've already attempted to use their psychiatry or forensic quackery to back up their claim here. And we're only starting to get into what we're about to look at. I've already gone through this multiple times. But as we start to look at the legislation that precedes it, we start to see that there is a very twisted way the state views rightful action from wrong, and terrorism to the extreme of stopping protesting activity against what could be considered industrial negligence, oil spill, nuclear power plant having a failure. That these are industrial accidents that could have forms of negligence that would require some form of dissent, and that is now turned into a terrorist act. So it's a very fine line the state's decided to play here. This, I guess, defines how a person disseminates information that would incite people into the aforementioned terrorist acts, which on the front side are pretty reasonable, and that's what you would expect in the protection of life, limb and the state. But when it turns itself into protest, dissent or industrial action, you start to see state protecting itself. So what is disseminating this kind of material? Would voting material be considered collecting or making documents likely to facilitate terrorist acts? 1. A person commits an offence if A. The person collects or makes a document, and B. The document is connected with preparation for the engagement of a person in or assistance in a terrorist act, and C. The person mentioned in paragraph A knows of the connection described in paragraph B. Penalty for imprisonment 15 years. Publishing information that is inciting any sort of violence or terrorism or dissent, in the sense of trying to stop a government from doing its duties to the public trust that it's obligated to manage, would be considered a criminal offence. But when it comes to protest and advocacy, so that would make Amnesty International a terrorist organisation for advocating action against what could be construed as humanitarian offences that Australia commits. So where does the line get drawn here? Are they publishing or collecting and making documents likely to facilitate anything? It's a fine line on defining who is at threat. Is the state at threat? Because the plaintiff is State of New South Wales here against a defendant. So obviously the state feels threatened. By what? That's the question. By what? Carrying on from part 3, we looked at what a terrorist act was and what preparing for or inciting others into a terrorist act is, which includes the collecting or making of documents likely to facilitate terrorist acts. This carries on to part 2. A person commits an offence if A. the person collects or makes a document, and B. the document is connected with preparation for the engagement of a person in or assistance in a terrorist act, and C. the person mentioned in paragraph A is reckless as to the existence of the connection described in paragraph B. Penalty: imprisonment for 10 years. 3. A person commits an offence under subsection 1 or 2 even if A. a terrorist act does not occur, or B. the document is not connected with preparation for the engagement of a person in or assistance in a specific terrorist act, or C. the document is connected with preparation for the engagement of a person in or assistance in more than one terrorist act. This again to me is double-sided, putting the scales of justice on both sides and having the inability to have justice, because a person commits an offence if a document is not connected with. That does not make sense. Okay, C would make sense. The document is connected with preparation for the engagement of. B does not make sense. The document is not connected. A terrorist act does not occur, or the document is not connected with the preparation of that act. That in itself is the same as before, the state protecting itself. Continuing on, 1016. Other acts done in preparation for or planning terrorist acts. 1. A person commits an offence if the person does any act in preparation for or planning a terrorist act. Penalty: imprisonment for life. I don't think that's fair, but a penalty should be imposed. 2. A person commits an offence under subsection 1 even if A. a terrorist act does not occur, or B. the person's act is not done in preparation for or planning a specific terrorist act, or C. the person's act is done in preparation for or planning more than one terrorist act. 3. Subsection 15(4), extended geographical jurisdiction, category D, applies to an offence against subsection 1. 12. Section 1021 of the Criminal Code defines terrorist organisation as follows. A terrorist organisation means A. an organisation that is directly or indirectly engaged in preparing, planning, assisting in, or fostering the doing of a terrorist act. Or B. an organisation that is specified by the regulations for the purpose of this paragraph, see subsections 2, 3, and 4. The United Kingdom of Australia has not been specified in the regulations as a terrorist organisation. It's a very key point early on in this document. It's a clarification under some serious legislation that the United Kingdom of Australia cannot be a terrorist organisation. It's a literal impossibility for the kingdom that is occupied to be the terrorist. It is the occupier that terrorizes. So it is a literal impossibility for any of the above to apply. And the judge, Justice Julia Lonergan, of the Supreme Court of New South Wales has directly recognised what I have done in the past for this to apply, and we will see this as we move further in. What we can also see is that the Australian government installed all of these acts because it knew that you would eventually rise up against it. And there are rules on the table when it comes to international armed conflict. We are seeing a lot of that in NATO, Russia, Ukraine at the moment. So this is not some small gesture that's been written here in this document. This is very specific in what is being said. The United Kingdom of Australia, UKOA, has not been specified in the regulations as a terrorist organisation, and as you will find out as we go on, it is literally an impossibility for that claim to be made. So we can see by the initial introduction to this court matter that applications were refused. Now, refused is a very strong word. It doesn't mean denied. If they were denied, they might have had a right to try. Refused tends to denote that they had no right to try in the first place. And we can see that it has not been specified in the regulations. And now this is where we get to a key point of a line of authority. The regulations are in what line of authority? 13. Sections 24 and 27 of the Act deal with the making of an interim order. Relevantly, those sections provide 24. Pre-trial procedures. 4. A preliminary hearing into the application is to be conducted by the Supreme Court within 28 days after the application is filed in the Supreme Court, or within such further time as the Supreme Court may allow. So they've given a 28-day period from the time of an application to follow all the rules that are set out in that application, or it will be denied. The court can extend that time frame, but at the court's will. 5. If following the preliminary hearing, it is satisfied that the matters alleged in the supporting documentation would, if proved, justify the making of an extended supervision order, the Supreme Court must make orders: A. Appointing I. 2 qualified psychiatrists, or 2 registered psychologists, or 3 1 qualified psychiatrist and 1 registered psychologist, or 4 2 qualified psychiatrists and 2 registered psychologists to conduct separate psychiatric or psychological examinations as the case requires of the eligible offender, and to furnish those reports to the Supreme Court on the results of those examinations, and B. Directing the eligible offender to attend those examinations. The offender must be present before these people. These people cannot do this from documentation. They must be present before, and again we come back to this: what is psychiatry? Is it a court factual forensic avenue of evidence, or is it hearsay? We come to a question: what is the mind? Is one without mind if one has cognitive process? What is cognitive? What is cognition? There's a lot of questions that come into what is mindful. So there is a lot of grey area in here that we will venture into as we go forward. This seems to be a rabbit hole that allows the state, as we've seen, they've set to defend themselves several times within their own legislation. There are a lot of grey areas in what they believe is evidence or proof of things which they may themselves be ignorant of. So this document's now laid out foundational legislation that's relied upon for these police applications to be heard in the first place. And we can see how at the very end of a period of detention, the police have rushed in and attempted to put together an application that would be within these guidelines according to them, and then pushed as hard as they could from their police prosecution to get these installed, made as orders. Interim orders would have been issued on the day, making that order start from that hour, and they would have been turned into permanent orders within the 28 days and carried on for the requested 3 years under the 55 anomaly orders that would have come along with it, which is where the police, believing that they have this upper hand in that they can surveil anybody that opposes some of their policy or their enactment of the policy of state, which would go against their oath that they'd taken. The principles articulated in the case law. 14. I gratefully adopt the summary of the principles to be applied at an interim hearing set out by Johnson J. in the State of New South Wales vs. Fired Preliminary 2020, New South Wales SC 1681 at 4452. 44. The task of the court at the preliminary hearing is to apply the statutory formula in S24(5) concerning the appointment of a psychiatrist and a psychologist to carry out examinations of the defendant, and at S27B concerning the making of an ISO. 45. Before making the orders sought by the plaintiff, the court must determine that the defendant's current custody or supervision will expire before the proceedings are determined, S27A, and that the matters alleged in the supporting documentation would, if proved, justify the making of an ESO, SS24(5) and 27B. 46. In the State of New South Wales versus Naaman, Number 2, the Court of Appeal, Baston, McFarlane and Leeming, JJA, described the court's task at a preliminary hearing as follows. At 17, my emphasis. Broadly speaking, the Act provides for a preliminary application to be made by the state, during which time interim orders, both for supervision and detention, and applications for orders appointing qualified psychologists and psychiatrists to conduct examinations of the person may be made. An order for extended supervision may only be made if there are reports from at least 2 psychologists or psychiatrists who have examined the person. See more particularly S24(5). The court, in determining whether or not to make the order, must have regard to those reports, S25(3)A. Broadly speaking, the test for making interim orders is that the matters alleged in the supporting documentation would, if proved, justify the making of an extended supervision order, S27. That determination will ordinarily be made in advance of the reports from the psychologists and psychiatrists, and in any event is a lower standard than applies to making of an extended supervision order. So she's pointing out that the court is pre all of these decisions, doesn't have the skills to perform these activities, and therefore will make orders without all of those things being interim until later an extended order could replace said interim order. And she would have to be satisfied that it would be worth putting that extended order in place at the time she decides whether it's worth putting the interim order in place. 47. This statutory interlocutory process exists in legislation intended to protect the community from, as she says, an application that be made by the state. A lower standard applies at a preliminary hearing to determine whether that application should proceed further, where the court will be assisted by expert psychiatric and psychological reports prepared after examination of the defendant. At a final hearing, the court will have the benefit of the reports by court-appointed experts with the THRO Act provisions to be applied at that hearing by reference to all evidence adduced by the plaintiff and the defendant. Definition: adduce, adduced past tense, adduced past participle, cite as evidence. A number of factors are adduced to explain the situation. So the justice is saying all the evidence added together from all the parties concerned. 48. This approach does not overlook the potential adverse consequences for the defendant if orders are made at the preliminary hearing. Rather, it reflects the statutory two-stage process where a lower hurdle applies at the interlocutory stage. Now, interlocutory application in a courtroom could be submitted over a single matter within a matter, and this medical intervention could be brought up as an interlocutory application during a larger case. 49. The court looks at the allegations and documentation through the lens of the plaintiff's case and takes them at their highest when deciding whether the test articulated in Section 27B THRO Act has been made good in all the circumstances of the case. State of New South Wales versus Narman, number 2, 2018, NSWSC 1329. State of New South Wales versus Elsmatua, 2019, NSWSC 186 at 4. 50. In undertaking the assessment at the preliminary hearing, the court is not involved in weighing up the documentation or resolving any conflicts, inconsistencies, or uncertainties which appear in the documentation. State of New South Wales versus Sturgeon, 2019, NSWSC 559 at 6. So the documentation provided can't have those inconsistencies in it, otherwise the judge is now ignorant herself of what you're asking for, and then therefore demonstrating that back on you have an incompetency to be able to provide that to the justice, and that's already documented in several court cases that we've just gone through. 51. It is necessary for the plaintiff to allege certain facts which, if proved, would lead to a conclusion that would justify making an ESO. State of New South Wales versus LMR, number 2, 2018, NSWSC 1034 at 7 to 10. 52. Section 27B THRO Act requires attention to be given to the matters alleged in the supporting documentation, a matter alleged should have some proper foundation and could not include matters of rumour, possibilities, unfounded in fact, or wholly unsupported speculation. State of New South Wales versus Allam, 2020, NSW SC 295 at 159. Making accusations that are based on rumour or unfounded facts and speculation is basically the reason for having to go through this process before you can enact your quackery from a state perspective upon an individual. This is now outlined because this protects everyone at this. This is very, very dark stuff that these police are requesting to be done to someone, which we will find out is over their beliefs. And those beliefs may have some fact to them. And that's the ignorant thing here, in that justice is recognised. A lot of things that the police have already done to push and jump the gun, like we said before. We move on next to the evidence. 15. The plaintiff relies upon the following evidences of some people that have submitted some documents before the court in a publishable court document. 15. The plaintiff relies upon the following evidence. Affidavit of Patrick Mullane, solicitor, sworn 12th of July 2021, exhibiting 2 volumes of materials as indexed and extracted from 13 volumes of material which it is said will be tendered on the primary application. Affidavit of Detective Senior Constable Matthew Reason, sworn 1st of July 2021. A detective in the Fixated Persons Unit. Affidavit of Senior Constable Alexander Clark, sworn 9 July 2021, an officer in the High Risk Terrorist Offenders Unit of the New South Wales Police. 16. The defendant relies upon affidavit of Hayley Lee, solicitor for the defendant, affirmed 20 July 2021. Affidavit of Todd Davis, affirmed 19 July 2021, outlining the role and reach of community treatment orders. Extract from the defendant's OIMS case management records dated 20 March 2020 and 9 April 2020, which makes reference to whether the defendant should be assessed for a concern that he has, in quotes, extremist views with peculiar ideation, close quotes. It is common ground that no assessment occurred. Right off the bat, we can see that the initial claims that brought this Matthew Reason from Fixated Persons Unit of the New South Wales Police into a position of being fixated on the defendant, that it was because of a peculiar ideation of some views that Matthew Reason would believe would be extremist, trying to paint and tar a brush on a body of people as a terrorist organisation. These actions came from the Fixated Persons Unit, which is a branch of the State Protection Squad of the New South Wales Police Force that was then used later in the Jordan incident with Friendly Geordies. The defendant's personal circumstances and the relevant history. The defendant was born in March 1970 and is 51 years of age. He works as a truck driver and at the time of arrest lived with his de facto wife and 2 sons. He has a criminal record involving driving offences in 1997 and a destroy and damage property in 2014. He came to police attention in September 2019 in the context of an assault charge involving a neighbour. His behaviour at Picton Local Court in October 2019 was odd in that he denied that he was the named defendant and asserted the arresting police were, by arresting him, committing crimes that should be tried in The Hague. The magistrate determined that if he, Mr. Kiskonen, was not in fact the defendant, then the person who was the defendant needed to be arrested, and that led to a warrant being issued. The defendant was duly arrested at court and proceedings continued. He failed to appear on the 29th of October 2019, leading to other charges. That's something that needs to be investigated as to the actions of the New South Wales Police in their fixation before the charges came about. What actions did you create that led to those charges? And would they be criminal on your part if they were reenacted today? 18. All of this led to his coming under the observation of the New South Wales Police Fixated Persons Unit, which, having observed him for a period, concluded via Detective Senior Constable Gatwood in December 2019 that he was not a threat at the time. All of this questioning the line of authority that a magistrate might have in a courtroom given certain circumstances that Matthew Reason believes are American in nature but are actually under the blessing of Almighty God as defined in the preamble to the Commonwealth of Australia Constitution Act July 1900. Maybe you should go read those words, Matthew. 19. However, concerns about him continued, and he was observed during both 2019 and 2020. Detective Senior Constable Reason, in his affidavit, sets out the bases upon which he holds concerns about the defendant as a member of the United Kingdom of Australia. What we can see here is that a man who challenged the court over what a person was at law was then fixated upon by fixated police named Fixated Persons Unit, and from that moment forward attempted to turn an organisation of faith into a terrorist organisation on purpose and with malice. It's very evident, and we haven't even got into the case yet. That's to me unbelievable that this would be so evident, and we're only at clause 18 of this document. Clause 19 then starts on this Detective Senior Constable Matthew Reason's affidavit that has been submitted, at which several paragraphs are then referred to. And we'll go into those paragraphs in detail as we go through this, because we're going to be able to demonstrate something very, very, very hard for a lot of these people to swallow. And that's the unfortunate truth in the matter. Okay, we carry on through this document. We'll return to 19. However, concerns about him continued, and he was observed during both 2019 and 2020. Detective Senior Constable Matthew Reason, in his affidavit, sets out the bases upon which he holds concerns about the defendant as a member of the United Kingdom of Australia, as follows. Matthew Reason had sworn affidavit 1st of July 2021, and these are paragraphs noted from his sworn affidavit. 6. The United Kingdom of Australia, brackets, quote, UKOA, quote, brackets, is an organisation which holds beliefs that are commonly referred to as those of the sovereign citizen movement. This means that they do not consider the laws of Australia to be legitimate, nor do they believe that such laws should or do apply to them. The ideologies of the sovereign citizen movement have their origins in a number of anti-government movements which emerged in the United States of America in the 1970s. UKOA is one of a number of sovereign citizen groups and individuals which I have been monitoring since commencing duties at the Fixated Persons Investigation Unit in 2018. 7. UKOA members adhere to a set of pseudo-legal theories which descend directly from American sovereign citizen theories, but which were adapted for the Australian context by Stephen Spires, brackets, quote, Mr. Spires, quote, brackets, comma, born 27 December 1973. Mr. Spires advocates for an alternative history of the world wherein both the United States of America and the United Kingdom were taken over by, quote, world bankers, end quote, due to their various war debts. 8. The original American ideology from which the UKOA thinking has been appropriated is more forthright in acknowledging that the, open quote, world bankers, close quote, are to be understood as Jewish. This latent anti-Semitism, along with an allied anti-Catholicism, is an undercurrent through UKOA thought. This can be seen in social media posts and other media published on the internet, both in overt references to supposed Jewish and Catholic influence, as well as coded language such as, open quote, world bankers, close quote, and, open quote, occupiers, close quote. I just don't know where to start, Detective Senior Constable Matthew Reason. I am like in laughter that this is the simplified side of your ideology at the police. You lay a 2 out on the table. The ideologies of a sovereign citizen movement detracts from God completely, Matthew. Like, it emerged in the United States, still relied on God to create Congress, and then Act of Congress 1871. You deny these things. So the ideologies of what? This bizarre statement to start with. Well, it's 6, 7 and 8 of the paragraphs of Mr. Matthew Reason, sworn 1st of July 2021, putting down a number of claims down on the table that can be easily rebuttable. and these things have been put before justices in the past, leading to a point where the answer will come eventually, and you start to make spurious claims. An organisation that is not deemed to be a terrorist organisation, and the oxymoron being how? Referred to as a sovereign citizen movement, but then later defined as occupiers. Quote, world bankers do not believe in the laws of Australia, and then there are laws that you need to follow. We have comments about you should be tried in The Hague. So you have 4 comments that don't equate to your after comments, which then don't equate to your sworn affidavit. And then you go on to make spurious claims that these ideologies were born from the United States of America, when you know full well that crowns have their foundations in English law, at which Australia's constitutional law is founded too. So how can that line be American in nature unless it came here and swapped some land for a peppercorn in 1967? That's a question you could ask. And then you go about saying that you've been monitoring, and it becomes apparent later how much, in a very fixated way over a group of people that you don't seem to comprehend at law. And you're the ones that are upholding the policy of those acts created by the Parliament of New South Wales that wouldn't comprehend this at law either. Which leads to what are pseudo-legal theories if they're born from truths that you yourselves are ignorant of. And then you make accusations of anti-government movements when respect for the ones that founded those governments in the first place is taking place. So you have turned something graceful into something of a matter of ignorance, I suppose. And what you've done is laid out very clearly your belief system, which can be rebutted by a long mile. So what does this say for New South Wales Police? Its commissioner, the minister, the New South Wales government, the governor, and the line of authority that is believed to be held there. As we carry on, this is almost laughable in what's being laid out. 9. In UKOA theories, as a dominion, Australia too is believed to come under the administration of those, quote, world bankers, end quote, despite being supposedly awarded its own kingdom, quoted, at the Treaty of Versailles. Ultimately, the Australian people were supposedly tricked into accepting occupation and slavery through the use of birth certificates which mortgage the individual to the corporation and represent an acceptance of the corporate law. In some manner, this corporation is believed to have ties to the Vatican. UKOA members believe that, as civilians in an occupied country, they have protections under the various laws of armed conflict which exempt them from the authority of police, the judicial system, and the laws of the federal and state governments. 10. Mr. Spires claims to have taken up the vacant line of authority of the Australian, open quote, kingdom, close quote, and has subsequently been declared by his followers as the, open quote, king, close quote, of UKOA. His two books, Realm and Man and Realm and Commonwealth, constitute the central documents of the belief system. Also important is a document entitled, open quote, Timeline, close quote, which was authored by Ua Kiskonen, open bracket, open quote, Mr. Kiskonen, close quote, close bracket, comma, born, open square bracket, redacted, close square bracket, 1970, and a document entitled, open quote, Bill of Rights dash I, close quote, which is of uncertain authorship. The stated aim of the UKOA movement is to declare the, open quote, true, close quote, Kingdom of Australia, remove its members from the authority of Australian law and place them instead under the authority of both, open quote, King, close quote, Spires, and an idiosyncratic conception of the common law. Ultimately, they believe that the Australian government and its occupying forces will be ejected from Australia, and various police, judges, politicians, and so on will be executed after being tried by military tribunals under the authority of The Hague. The interest public officials is a recurrent theme, appearing in videos, memes, and online discussion distributed online. 11. Prior to the involvement of Mr. Kiskonen and, in particular, the advent of the Mr. Spires was one of the many theorists in the Australian sovereign citizen community. His abrasive interpersonal style and claim to be the Australian monarch tended to alienate others and led to him being the subject of considerable ridicule. This changed noticeably when the COVID appeared to contribute to a sudden interest in conspiracy theories about and concerns over quarantine restrictions. Many individuals searched for answers via social media and encountered sovereign citizen ideology, which appeared to offer an answer to these concerns. Many individuals appeared to draw upon the involvement of Mr. Kiskonen, which took the UKOA doctrine and explained it in a simpler, less hostile, and more charismatic fashion. His authorship of the, open quote, timeline, close quote, document, his numerous YouTube videos, and online commentary meant that individuals could access UKOA theory in a simpler and more entertaining fashion. Based upon the engagement with the material online that I observed in my surveillance of UKOA internet sites, this appeared to be more popular than reading Mr. Spires' books. There's the little comma on the end of Spires there, which are voluminous, poorly written, arcane, and somewhat convoluted. Conversations I have had with members of UKOA tend to reference the works of Mr. Kiskonen more frequently and specifically than those of Mr. Spires. The latter are revered, but it is unclear how many followers of the UKOA have read them in any detail. Totally bizarre. I'm like, thank you and thank you. As a dominion, how did Australia get this status as a dominion, Mr. Matthew Reason? See, we had this constitution, right? And that Clause 8 of this constitution, there were colonial boundaries, whereas the states previous to this 1901 date, they were colonies, and they had colonial boundaries that were detailed in the Colonial Boundaries Act, which was then subsequently repealed at the time of the formation of the Constitution Act, because it's part of the Constitution Act, at which Clause 9 holds the Constitution, at which the schedule links Almighty God to the preamble that's found at the beginning of that act. A kingdom is something that is fought for by those that died, 62,000 plus 2,500 Aborigine plus over 2,000 Maori, all sacrificed life and limb for the very premise of freedom that came with what was introduced at the Treaty of Versailles, allowing an independent and sovereign nation to join the League of Nations, which then led to an Imperial Conference 1926 and then Statute of Westminster 1931. Your answers are right in front of you, and you can deny them all you like. That's just the facts that are laid out on the table. The Bill of Rights applies through New South Wales in Acts, Application Acts, as it does in every other state. There is an ideology here that is very skewed from what is actually presented at law, because we're not talking about an opinion here. There's a police officer that has taken it upon him and his team as a part of State Protection Squad, working to protect the state of New South Wales, filing on behalf of the state of New South Wales, as demonstrated by the title of the case, put very strongly a position down in the Supreme Court. You're trying to attribute this to some sort of hostile action, which could be construed as laughable, given that the hostility has been clearly demonstrated to have come from the state. And moving on again, let's just jump straight into it. 12. Mr. Kiskanen administers a YouTube account, John K., which has 1,930 subscribers, and 2 Facebook accounts, Dua Kulave Kiskanen and Dua Kiskanen, which are followed by 926 and 950 people respectively. UKOA also has a number of Facebook groups in which Mr. Kiskanen has also been active, including the discontinued group Remaining Loyal to the Kingdom of Australia, which had 2,300 members, and the successor site Introduction to the Anzac Research Group, which has 1,500 members. These are believed to be the public sites from which more dedicated members are eventually invited to closed groups for further discussion. It has been my observation that Kiskonsen's posts, and his videos in particular, were a major focal point for UKOA. Videos produced by Mr. Spires were often introduced and referred to Mr. Kiskanen through his various formats. So, Mr. Matthew Reason, why aren't my videos included in the attached evidence? That's kind of bizarre, or we would refer to my videos. 13. Mr. Kiskanen's YouTube channel was a major focal point of the movement and a venue from which he regularly told his viewers that they did not have to obey the law or the police, and encouraged confrontation. For example, the YouTube videos Notice to Police, 27 July 2020. New South Police have a lot to answer for, 5th of May 2020. Only citizens can be fined by police, 11 April 2020. New South Wales Police are getting the picture, 20th of May 2020. Police, treaties and the common laws of war, 7th of May 2020. New South Wales Police take notice, 6th of May 2020. There are rules we must follow, 1st of May 2020. In a YouTube video on the 26th of June 2020, How to Get Off the Citizenship, Mr. Kiskonen told viewers that they were actually required to ignore the law as subjects of the UKOA. On the 27th of July 2020, YouTube video Notice to Police, he stated that he would no longer be attending court when required to do so. He suggested that he would not be pursued in regard to his non-appearance, as the courts and police would know he was beyond their jurisdiction. There is a little confusion in Matthew Reason's head here, but let him go about laying out all these things on the table. 14. On 25 May 2020, Mr. Kiskonen posted a video on YouTube in which he indicated that Mr. Spires had been declared King of Australia and encouraged people to make the oaths of allegiance. This was followed by an online campaign through YouTube and Facebook of getting as many individuals to swear allegiance as possible. As a part of the emergence of the kingdom, a campaign of raising the red ensign flag at war memorials across Australia was undertaken, beginning with Mr. Kiskonen doing so at Campbelltown on 17th of July 2020. It is believed that Mr. Kiskonen declared himself to be the Lord Mayor of Campbelltown on this occasion. The red ensign flag, and specifically an early version of it, is used by UKOA as their flag. UKOA adherents believe that it signals their jurisdiction and that by flying it they render themselves immune from action by police under international law. Mr. Spires and others have advocated a theory that this is a land flag which places them outside the jurisdiction of Admiralty law as represented by the blue Australian national flag. So there you go. Your red ensign is listed in the Supreme Court as a land flag in opposition to an Admiralty flag that was raised above your Parliament in the Flags Act 1953-54. So these statements that will obviously continue into the next slide are the affidavit of a Detective Senior Constable Matthew Reason of the Fixated Persons Unit of the State Protection Squad of the New South Wales Police Force, directed by people in the executive branches of government. Mr. Reason knows a lot more than he's alluding to from his police position. He's spoken to me on the phone in relation to quite a few things that still have gone unanswered at law. There's a learned point of view coming from this application, is what I would say. You also have to understand that these are the words of a police officer working in a group of police officers with an aim to stop and take down a man in relation to his beliefs, which are outside of the doctrine that is being thrown around by the state. Matthew Reason has made quite a load of spurious claims, which up to 15 of his affidavit has yet to prove any belligerence or hostility that comes from a group of people attempting to remember their past. We're obviously more than halfway through Matthew Reason's affidavit, and he's laid out a claim that he believes. Whether that's what he believes we believe is another story altogether. But it's definitely a claim of what he believes, laying down a very specific trail of words, that there are sentence structures within Matthew Reason's affidavit that have come from a learned police standing, and the constant switching between names of family name and Mr. and abbreviated title versus title. What is evident is that there are very specific things now detailed within the first page of entering into this case. That there are things named by title, there are things described, there are things referred to, there are actions that have been referred to, and as we've seen from the introductory legislation, the United Kingdom of Australia is not a terrorist organisation. It is a literal impossibility for it to be so. No judge would sign off on that. So we come to learn that Matthew Reason has overly laid out some very specific allegations in a repetitive and switching form in a hope to cover all bases while he jumped the gun, and is probably now thinking, should I have done that? It gives credence to something that, at international law at least, would see some repercussions take place. Right, we keep moving through the affidavit of Detective Senior Constable Matthew Reason, dated on the 1st of July 2021. We continue at paragraph 16. On the 4th of July 2021, Mr. Kiskonen announced that UKOA would be holding an, open quote, Australia Day, close quote, ceremony on the 31st of July 2020. This was to occur at the main war memorial in each state capital. Police subsequently learned that this was intended to be a day at which the Kingdom of Australia was to be declared and the red ensign was to be consecrated. It was also intended to remove any Australian national flags from the monuments and replace them with red ensign, singular. In his video, Mr. Kiskonen outlined plans for, open quote, mass oaths, close quote, and an intent to put the Government of Australia, open quote, on notice, close quote. This was to be the most significant event in UKOA history to this date. Mr. Kiskonen spent a great deal of time and money organising this event, which he comments on in his videos, and included Mr. Kiskonen writing speeches, purchasing flags, and having flyers printed. While Mr. Kiskonen was ultimately arrested prior to the event, simultaneous events did go ahead in Sydney, Melbourne, Brisbane, Perth, and Adelaide. With the exception of Adelaide, these individuals were prevented from interfering with the memorials through intervention of police. So a self-admitted jump the gun, intervening on something that was peaceful, which then threw mud in your faces for the way you acted. 17. Prior to their, open quote, Australia Day, close quote, ceremony on the 31st July 2020, UKOA had a considerable online following in most Australian states, with a smaller group of serious adherents who had sworn formal oaths to the, open quote, King, close quote, and who made UKOA a central part of their lives. Based on my investigations, I estimate that the latter group comprised approximately 100 persons situated mostly in Victoria, New South Wales, Western Australia and Queensland. The group had a managing body, the Australian Royal Council, SIC, a number of subcommittees, and was appointing its own local officials to districts within which the members lived. A bureaucratic administrative process emerged in which communications were carried out through formal minutes, document transmission policies, and an online document management system administered by, apparently, Mr. Spires. So, was it managed by Mr. Google on Mr. Google's drive? There is a document that we could publish again, which was the non-violent direct action document, demonstrating that there was a peaceful and non-violent directive behind it all. So Matthew Reason has now labelled a large body of people. It's more than 100, because 100 is this sort of core group, and this 100 is scattered across towns and cities across Australia, and there are others in those towns and cities across Australia that have obviously come to realise there is something afoul with the Australian government. And it's not so much that what is being presented is true or not in that respect, it's the fact that they have realised that there is something afoul in the Australian government. And the lack of answers from that government, add to the suspicions that these people already have. This statement, dated the 1st of July 2021, is over a year after the events that are being detailed down in these statements. So you would have learnt a few things within 12 months as well. And you would now be looking to cover your own ass post facto. That's something that I'm seeing. It's specific. This is coming from New South Wales Police in a very specific but non-specific way. It's all over the place. It's on both sides of the table. It's up and it's down. It's accusatory, but it's accepting at the same time. It's kind of bizarre. It's like you're covering your own asses post facto. Like, this is a year later, these words are being spoken in relation to the events that occurred, that were triggered by you. So that's just what I see. So this statement now jumps from paragraph 17 to paragraph 23. And we continue on in the words of Detective Senior Constable Matthew Reason. I continued to monitor the social media activity of Mr. Kiskonen, Mr. Spires, and the UKOA community as a part of my monitoring and investigation activities for the Fixated Persons Investigation Unit. Over a period of months, it's a bit fixated, isn't it? I observed increased activity and rhetoric indicating that Mr. Kiskanen and Mr. Spires were beginning to formalise the UKOA community and were increasingly advising their members that they were above the law. And Jesus kind of said, didn't come to break the law, we came to fulfill it. As detailed above, Mr. Kiskanen posted a number of videos specifically referring to the police. From May to July 2020, I was aware that Detective Senior Constable Gatwood was receiving emails from Mr. Kiskanen. These emails caused both Detective Senior Constable James Gatwood and I, Matthew Reason, to form the opinion that Mr. Kiskanen was becoming increasingly radical. As he was becoming increasingly passionate about his beliefs, strident in his opinions, and increasingly focused on his supposed immunity from the law and on the eventual execution of traitors, and was attempting to recruit Detective Senior Constable Gatwood into UKOA. That's an interesting prospect of something that I was completely unaware of. Did he answer the questions? Are there still open questions at law that you use force instead of mind to address? 24. I also became aware of plans to hold a UKOA open quote Australia Day close quote ceremony on the 31st July 2020. Mr. Kiskanen's YouTube video indicates that Mr. Kiskanen was working at an increasingly frantic pace to get preparations in place for this event. He referred to not having had enough sleep on a number of occasions and spoke a number of times about how busy he was. I am aware that he was writing speeches, having brochures printed, ordering flags, designing ceremonies, and liaising with individuals in a number of other states. His level of activity at this time was noticeably higher. It's pretty clear that your activity, Mr. Matthew Reason, was higher than everyone else's, being so fixated on this. You could have just answered questions instead of turning the cheek and going into this attack, and it's slimy attack too. 25. On 23 July 2020, Detective Senior Constable James Gatwood showed me an email response that he intended to send to Mr. Kiskanen, in which he responded to Mr. Kiskanen's request to explain why he did not believe in the UKOA doctrine. I agreed with Detective Senior Constable Gatwood that it was important to attempt to resolve this issue in Mr. Kiskanen's mind to prevent him from believing he had support for his ideas within New South Wales Police. We have had indication of their attempt to bring this before a psychiatrist, at which they are using specific language in their bid to have that succeed for the state. It's a very dark issue when a police officer then, in his very own statement, says it was important to attempt to resolve this issue in Mr. Kiskanen's mind to prevent him from believing. All they had to do was answer questions. They've turned that into a situation where they can use quackery or hearsay. 26. On 27 July 2020, as I foresaw the potential for violent confrontation, I advised... It's kind of weird language, Mr. Matthew Reason. As I foresaw the potential for me to jump in and cause a melee, I advised other relevant law enforcement agencies of the plans of UKOA to attend major war memorials in Australian capitals and conduct various ceremonies, remove any national flags there, and raise their own red ensign in its place. The fact that you can foresee things and then want to reprogram someone's doctrine, it puts this whole mind game at a different level when you can see into the future, but someone's not allowed to see into the past. There was no directive to take down any national flags at any war memorials. There is actually evidence of people taking flagpoles with them so that they could raise red ensigns in memorial of the Anzac. 27. Also on 27 July, Mr. Kiskonen posted a video on YouTube entitled, open quote, "Notice to Police," close quote, in which he appeared to make a threat towards Detective Gatwood and to police generally. Was Detective Gatwood named? I don't know this video. At this time, I began preparations to arrest Mr. Kiskonen and took over the role of officer in charge from Detective Gatwood. I took over. At this time, I began preparations to arrest Mr. Kiskonen and took over the role of officer in charge from Detective Gatwood. You're the detective senior constable. He's a detective senior constable. Who's in charge of what exactly? The investigation activities for the Fixated Persons Investigation Unit, which you were fixated upon for a period of months, observing increased activity and rhetoric, participating in that activity to generate that rhetoric, perhaps. 1. Affidavit DSC Matthew Reason, dated 1st of July 2021, displaying paragraphs 6 through 17, 23 through 27. Now we move into some of the factual record at 20. So we've gone through Matthew Reason's affidavit at 19. 20. These activities led to the arrest of the defendant at his home on 30 July 2020. He was charged with 2 counts of use carriage service to menace, harass and/or offend, and with firearm offences related to a, quote, gel blaster pistol, end quote, found at his home. So what made you end up at his home, Matthew? That's the key indicator here. How did you find something at his home? What led you to entering his home? This use of carriage service was proven to be false. So now you have to explain what led you to taking command of a investigation that led to entering someone's home. 21. According to Detective Senior Constable Matthew Reason's affidavit, the defendant's take on his own activities was that his videos were not threatening but telling the truth about what would happen. This is a statement from Justice Julia Lonergan in her report. So it's just making note of the fact that it's not a threat, but it's the telling the truth about what would happen. Don't forget, Matthew Reason previously had stated that it was important to resolve this issue in Mr. Kiskonen's mind to prevent him from believing. These are Matthew Reason's own words. 22. Detective Senior Constable Matthew Reason noted that the open quote Australia Day ceremony close quote discussed in the defendant's post did go ahead on the 31st of July 2020, with UKOA members attending war memorials in Sydney, Melbourne, Adelaide, Perth, Brisbane, Cairns, Mackay, Launceston, Geelong and Canberra. Detective Senior Constable Reason said that the ceremonies in Sydney, Melbourne and Perth all exceeded 20 attendees, and attendees were arrested or moved on in Melbourne and Sydney. And this is an outright lie, Matthew Reason. That these are your comments being noted here that disagree with something that we're already touching on but haven't got to yet. 23. There is other evidence relied upon by the plaintiff, the New South Wales Police Force, in the form of YouTube and Facebook material posted by the defendant and the comments posted by others in response. This is now the solicitor's affidavit, at which he put in several volumes of information, which would have then bogged down the court with a flood of information, leading to what is more than a screen's worth of comment on that information, which as we go forward is actually 4 screens, more than 4 screens worth of referred to information that's been tendered in evidence as volumes, over 12 volumes if I remember correctly. Right, so that these are just references to these volumes. Let's just nail them on the head. Investigation of Mr. Kiskonen's social media accounts and Exhibit AC1 or I. 25. So there's a transcript at which the justice is now only taking a handful of numbered references from this submitted archive of information. 25. On 16th of June 2021, I began my investigation into social media accounts believed to be operated by Mr. Kiskonen. My duties during this investigation process is to conduct a review and capture of social media handles, profiles utilized by Mr. Kiskonen. That sounds very fixated that you have to do something like that. On the 23rd of June 2021, 25th of June 2021, 30 June 2021, I navigated to and reviewed various Facebook and YouTube accounts as a part of my investigation into Mr. Kiskonen. Of the accounts I reviewed, I downloaded 2 Facebook accounts in portable document format, in addition to various videos from YouTube in MP4 form so they could be accessed offline. So you ripped these YouTube videos off YouTube, did you? Using what software? One of those free downloaders online? And you printed it to a document You printed what was on screen to a PDF. That's, I navigated to and reviewed, like you're an expert at what you do. 26. In order to capture the Facebook profiles, I utilized a tool called the snipping tool to take screenshot the window and the print to PDF function to directly save copy of the page contents. A program called Snagit was utilized to record the YouTube videos. So, did you pay for Snagit? You're using Windows 10, I take it, with the snipping tool down in the bottom right hand corner and a print to PDF function in the Edge browser. All that Microsoft supported stuff they gave you for free, no doubt. Facebook accounts believed to be operated by Mr. Kiskonson. 28. While conducting the investigation referred to at paragraph 25 above, I navigated to a Facebook account located at the URL https://www.facebook.com/UHA Kiskonen. At all times during my investigation, the username for this account was Juha Kalevi Kiskonen. I will refer in this affidavit to this account as the Juha Kalevi Kiskonen Facebook page. Fair enough in that you're playing an investigative role, but geez, this becomes fixated, doesn't it? When then this is what the state's time is spent doing. 29. On 25th of June 2021, I navigated to the Juha Kalevi Kiskonen Facebook page and downloaded the entire timeline as it appeared to me, including thumbnails of the accounts, friends, pages liked, photographs posted, posts written and content shared by the operator of that account between the dates of the 1st of October 2019 and 27th of July 2020. This download is contained in tab 343 of Exhibit AC1, in tab 343 in the exhibit. That's 342 fixated tabs fixed to a document highlighting 342 incidents before 29. 30. On the 5th of July 2021, I reviewed the Juha Kalevi Kiskonen Facebook page and noted the following replies to various posts made by that page. Now I'm fixated on all of the other people on that page, and it's become guilt by association. We get to a point where a solicitor has dumped a whole bunch of files onto the record. They're being referred to, which leads to a whole bunch of responses to what would be Facebook posts listed in evidence. 30. On 5 July 2021, I reviewed the Juha Kalevi Kiskonen Facebook page and noted the following replies to various posts made by that page. This then goes on to list a bunch of replies. On 18 May 2020 at 17:51, a Facebook account bearing the name Anthony Joseph replied to a post made by the Juha Kalevi Kiskonen Facebook page on 18 May 2020. That reply, containing the words, quote, "They pull a gun on us, we can shoot back lawfully in self-defense," end quote, is located at page 2584, tab 343 of Exhibit AC-1. On 18 May 2020 at 17:33, a Facebook account bearing the name Cher Wilson replied to a post made by the Juha Kalevi Kiskonen Facebook page on 18 May 2020. That reply, containing the words, quote, "Shoot them all," end quote, is located at page 2584, tab 343 of Exhibit AC-1. On 29 April 2020 at 12:58, a Facebook account bearing the name Craig Nichols replied to a post made by the Dua Kalibi Kiskonen Facebook page on 28 April 2020. That reply, containing the words, quote, "Cops will end up in gutters," end quote, is located at page 2620, tab 343 of Exhibit AC-1. On 28 April 2020 at 17:27, a Facebook account bearing the name Danny Steppen replied to a post made by the Dua Kalibi Kiskonen Facebook page on 28 April 2020. That reply, containing the words, quote, "Start chopping heads again," end quote, is located at page 2622, tab 343 of Exhibit AC-1. On 18 January 2021 at 14:43, a Facebook account bearing the name Shane Harrison replied to a post made by the Dua Kalibi Kiskonen Facebook page on 18 January 2020. That reply, containing the words, quote, "Hang together or hang alone, and we have to stand together," end quote, is located at page 2916, tab 343 of Exhibit AC-1. 11 December 2019 at 2019, a Facebook account bearing the name Peter Schubach replied to a post made by the Dua Kalibi Kiskonen Facebook page on 11 December 2019. That reply, containing the words, quote, "Not if they are all hung," end quote, is located at page 3138, tab 343 of Exhibit AC-1. On 10 December 2019 at 12:22, a Facebook account bearing the name Paul Edward Johansson replied to a post made by the Dua Kalibi Facebook page on 10 December 29. That reply, containing the words, quote, "Hang the bastard," end quote, is located at page 3143, tab 343 of Exhibit AC-1. On 5 November 2019 at 20:33, a Facebook account bearing the name Paul Edward Johansson replied to a post made by the Dua Kalibi Kiskonen Facebook page on 5 November 2019. That reply, containing the words, quote, "We may, as has happened in many other countries, use guerrilla warfare to bring the country to a standstill," end quote, and, quote, "I pray it doesn't happen, but I am prepared to take the necessary measures," end quote, is located at page 3286, tab 343 of Exhibit AC-1. On 1st December 2019 at 07:47, a Facebook account bearing the name Mike Woods replied to a post made by the Dua Kalibi Kiskonen Facebook page on 30 November 2019. That reply, containing the words, quote, "Treasonous bastards need hanging," end quote, is located at page 3186, tab 343 of Exhibit AC-1. On 8 November 2019 at 03:06, a Facebook account bearing the name Brett R. Payne replied to a post made by the Dua Kalibi Kiskonen Facebook page on 8 November 2019. That reply, containing the words, quote, "This can be used as a rope, and they will tie the noose and hang themselves," end quote, is located at page 3269, tab 343 of Exhibit AC-1. That kind of brings a list of replies to certain things, but the things aren't really in front of us. And then it leads on to 31. While conducting the investigation referred to at paragraph 25 above, I navigated to a Facebook account located at the URL https://www.facebook.com/DuaKiskonen9. At all times during my investigation, the username for this account has been Dua Kiskonen. I will refer in this affidavit to this account as the Dua Kiskonen Facebook page. 32. On 23rd June 2021, I navigated to the Dua Kiskonen Facebook page and downloaded the entire timeline as it appeared to me, including thumbnails of the account's friends, page liked, photographs posted, posts written and content shared by the operator of that account between the dates of 16 December 2019 and 22nd July 2020. This downloaded is contained in tab 344 of Exhibit AC1. The entire timeline. I just kept scrolling down like an ex-girlfriend. I needed to know what he was up to. I fixated on this. I just can't let it go. 33. On 5 July 2021, I reviewed the Euarchus Conan Facebook page and noted the following posts made by that page and various replies made to posts by that page. So we get another list of commentary from different posts. 33. On 5 July 2021, I reviewed the Euarchus Conan Facebook page and noted the following posts were made by that page and various replies made to posts by that page. On 20 March 2020 at 22:13, the Euarchus Conan Facebook page made a post containing an image of Prime Minister Scott Morrison and armed police containing the words, quote, "Toe the line, citizen, or else," end quote. This post is located at page 3556, tab 344 of Exhibit AC-1. On 20 March 2020 at 22:54, a Facebook account bearing the name Dale Jorgensen replied to the post made by Euarchus Conan Facebook page referred to at paragraph 33A above. That reply with an image of a rifle overlain with the words, quote, "You've got your point of view and I have mine," end quote, and is located at page 3557, tab 344 of Exhibit AC-1. On 23 March 2020 at 21:57, a Facebook account bearing the name Ray Rowley replied to the post made by the Euarchus Conan Facebook page referred to at paragraph 33A above. That reply was comprised of an image containing the silhouette of a man with a pistol held to the back of his head and a comment. This reply is located at page 3559, tab 344 of Exhibit AC-1. On 13 March 2020 at 19:37, a Facebook account bearing the name Paul Blart replied to the post made by the Euarchus Conan Facebook page containing the text, quote, "All of you that mocked, ... I'm going to enjoy watching you all suffer," end quote. The reply containing the words, quote, "I want to see every city-dwelling pro-government sheep slaughtered, then we can get on with life," end quote, is located at page 3603, tab 344 of Exhibit AC-1. On 13 March 2020 at 22:58, a Facebook account bearing the name Paul Figures replied to a post made by the Euarchus Conan Facebook page on 13 March 2020. That reply containing the words, quote, "Power is dry, eyesight is good, I know where high ground is," end quote, is located at page 3622, tab 344 of Exhibit AC-1. On 15 March 2020 at 10:08, a Facebook account bearing the name Barry Don't replied to the reply made by the Facebook account bearing the name Paul Figures, referred to at paragraph 33E above. That reply containing the words, quote, "Just make sure you correctly ID the target before firing. No civilians, no combatants are unarmed. Beware the Trojans," end quote, is located at page 3622, tab 344 of Exhibit AC-1. 34. While conducting the investigation referred to at paragraph 25 above, I navigated to the website YouTube at http://www.youtube.com and typed, quote, "UKOA John K," end quote, into the search bar on the YouTube website. As a result of this search, I located the YouTube subscriber channel titled, quote, John K, end quote. I will refer in this affidavit to this subscriber channel as the, quote, John K, end quote, YouTube page. It's a bit obsessive, like subscriber channel, like everyone needs a subscription here, roll up, roll up. It's a mystery tour. 35. On 30 June 2021, I navigated to the John K YouTube page and downloaded the subscriber channel as it appeared to me, including thumbnails of videos posted by that subscriber channel, the number of subscribers to the subscriber channel, and the number of videos posted by that subscriber channel. At that time, the John K YouTube page had, quote, 1.93k, end quote, subscribers, and had posted a total of, quote, 288, end quote, videos. This download is contained in tab 345 of Exhibit AC-1. Did you download all 288 videos with your little video downloader app? 36. On the 30 June 2021, also downloaded the following videos posted by the John K YouTube page. A video titled Call Out to Help Our Man Thursday 16 of July, posted on 10 July 2020 and is 8 minutes and 6 seconds in length. This video currently has a total of 521 views, and with comments hidden by the restricted mode, as well as 55 thumbs up and 1 thumbs down. A copy of this video is located at tab 346 of Exhibit AC-1. A video titled Is It the End? Posted on 11 July 2020 and is 28 minutes and 18 seconds in length. This video currently has a total of 2,168 views, with the comments hidden by restricted mode, as well as 172 thumbs up and 1 thumbs down. A copy of this video is located at tab 347 of Exhibit AC-1. A video titled Rise vs Fall, posted on 12 July 2020, is 33 minutes and 10 seconds in length. This video currently has a total of 801 views, with comments hidden by restricted mode, as well as 73 thumbs up and 2 thumbs down. A copy of this video is located at tab 348 of Exhibit AC-1. A video titled Why Oath to Stephen, posted on 16 July 2020 and is 19 minutes and 57 seconds in length. This video currently has a total of 1,839 views, with the comments hidden by restricted mode, as well as 129 thumbs up and 13 thumbs down. A copy of this video is located at tab 349 of Exhibit AC-1. A video titled A Chat with the Honourable Matthew, posted on 22 July 2020 and is 1 hour 9 minutes and 5 seconds in length. This video currently has a total of 989 views, with the comments hidden by restricted mode, as well as 85 thumbs up and 2 thumbs down. A copy of this video is located at tab 350 of Exhibit AC-1. A video titled New South Wales Police Have a Lot to Answer For, posted on 5 May 2020 and is 4 minutes and 43 seconds in length. This video currently has a total of 489 views, with comments hidden by restricted mode, as well as 60 thumbs up and 1 thumbs down. A copy of this video is located at tab 351 of Exhibit AC-1. A video titled Only Citizens Can Be Fined by Police, posted 11 April 2020, is 13 minutes and 26 seconds in length. This video currently has a total of 824 views, with comments hidden by restricted mode, as well as 98 thumbs up and 5 thumbs down. A copy of this video is located at tab 352 of Exhibit AC-1. A video titled New South Wales Police Are Getting the Picture, posted on 20 May 2020 and is 3 minutes and 43 seconds in length. The video currently has a total of 5,135 views with comments hidden by restricted mode, as well as 255 thumbs up and 3 thumbs down. A copy of this video is located at tab 353 of Exhibit AC-1. A video titled Police Treaties and the Common Law of War, posted 7 May 2020, is 24 minutes and 56 seconds in length. The video currently has a total of 674 views with comments hidden by restricted mode, as well as 70 thumbs up and 3 thumbs down. A copy of this video is located at tab 354 of Exhibit AC-1. A video titled New South Wales Police Take Notice, posted on 6 May 2020 and is 15 minutes and 30 seconds in and is 15 minutes and 13 seconds in length. This video currently has a total of 797 views with comments hidden by restricted mode, as well as 88 thumbs up and 4 thumbs down. A copy of this video is located at tab 355 of Exhibit AC-1. A video titled There Are Rules We Must Follow, posted on 1 May 2020 and is 8 minutes and 22 seconds in length. This video currently has a total of 526 views with comments hidden by restricted mode, as well as 58 thumbs up and 3 thumbs down. A copy of this video is located at tab 356 of Exhibit AC-1. A video titled How to Get Off the Citizen Ship, posted on 26 June 2020 and is 10 minutes and 51 seconds in length. This video currently has a total of 831 views with comments hidden by restricted mode, as well as 101 thumbs up and 2 thumbs down. A copy of this video is located at tab 357 of Exhibit AC-1. And lastly, a video titled Wayne Glue is a Traitor, posted on 12 June 2020 and is 15 minutes and 13 seconds in length. This video currently has a total of 1,308 views with comments hidden by restricted mode, as well as 65 thumbs up and 20 thumbs down. A copy of this video is located at tab 358 of Exhibit AC-1. Affidavit of SC Alexander Clark, dated 9 July 2021 at paragraphs 25 through 36. This then moves into actual legal matter. So we've now just gone through what evidence has been laid out on the table. We can see the fixation that this fixated persons unit has to document and download the amount of material that it has, in the hope that there's something in that material that they can use in their bid to turn something into a terrorist organization. That's just a literal impossibility at the cornerstones of law. Okay, we've now gone through a plethora of evidence put down in archives. So they've literally put this on the state record in the thousands of pages. And we finally come to the charges themselves, which are a little bit obscure in themselves given the surrounding information and the actions of fixated persons unit, who seem to be overzealous in just about everything they've done so far, including the dumping of thousands of documents onto the court. 24. It is against this background that the materials, the subject of the charges, was published and sent by the defendant to DSC Gatwood, to Detective Senior Constable Gatwood, on 25 May 2020 and 27 July 2020. The key points of this correspondence are relevantly summarized in the police facts. So correspondence was sent twice, 4 to 5 weeks apart, to the same police officer. Offence 1. Use carriage service to menace, harass, offend. On the 25th of May 2020, the accused uploaded a video to YouTube and shared it to the Remaining Loyal to the Kingdom of Australia face group I had become a part of. The video showed the accused providing commentary about spires, all caps, this now a new way of addressing a title, being the new King of Australia, and that they will now be, open quote, challenging this government big time, full stop. We are going to put them in their place, close quote. He goes on to say that all police officers and army personnel will be held accountable if they do not make an oath to ... Kingdom of Australia. There will be consequences for your treason, close quote. The accused stated that those who do not swear an allegiance will be hung and their, open quote, ... necks snapped, close quote. The accused stated his followers were required to advise him of their oath to King Stephen and, spelling mistake, that from today on, open quote, ... things are changing, close quote. This video can be seen to have been filmed in an area of the garage at the accused home at, open square bracket, redacted, close square bracket, Gregory Hills. Offence 2. Use carriage service to menace, harass, offend. On the 27th of July 2020, the accused posted a video of himself to his YouTube page. The video was a 20-minute recording titled, open bracket, Notice to Police, close bracket. During the video, the accused stated that he had a document that put the police on notice. He began to talk about police and stated, open quote, the one that surprised me the most was the fixated persons unit. A detective there named James. G'day James, how you going? I know you watch. Very surprised at your response, James, although I realized why you made that response. I mean, like your job? But is your job worth your life, mate? That's the thing. Not saying I'm going to do anything about it, but you can read all of the material, ... I was only looking out for you, ... But obviously your job is more important than your country. So I guess that puts you in a special kind of category. It starts with T. I'm sure you know what that word is. The accused continued to talk about police, and if they go against the Kingdom of Australia, that they will be hanged. The accused did this by making a hanging motion. The accused has subsequently indicated during HSI sick interview, during, spelling mistake, his interview, that T stands for treason, could also stand for traitor. This video is identifiable as having been filmed in the accused garage at, open square bracket, redacted, close square bracket, Gregory Hills. In the video, the accused later referred to Gatwood, all caps, and police stating, open quote, you need to realize that when you know you're committing treason and you continue to commit treason, open bracket, the accused made another hanging motion, close bracket. It does lead to that. The accused referred to the king taking power, stating, open quote, Do you think you're going to be able to stay here and avoid a hanging? ? Close quote. The accused continued to threaten that police will be hanged. He talked about hanging certain police, stating, open quote, "Fuck yeah, we should ... I'm not going to beat around the bush. I'll get a bit of pleasure out of it." Close quote. The accused stated that the only way anyone will avoid hanging would be by changing their allegiance. Close quote. There's a bit of assumption going on during the twisting of words that might mean something else. We'll just flip over the page quickly. And 25, the firearm offences are described in the police facts as follows. The police facts. Offence 3, possess unregistered firearm, prohibited pistol. Offence 4, not keep firearm safely. During the search of the premises, the question is, how did you get there in the first place? Police located a, open quote, gel blaster, close quote, pistol on a shelf in the garage. This shelf is close to an area in which the accused films his videos. The pistol, sick, double S, spelling mistake, resembles a conventional semi-automatic pistol and fires small plastic projectiles. It actually doesn't fire small plastic projectiles. It fires gel. It is an automatic firing and is classed as a firearm, prohibited pistol at law. The firearm is not registered and was not secured in an approved safe. The accused is not currently licensed to own a firearm. The accused participated in an electronically recorded interview wherein he made admissions to operating the, open quote, John K, close quote, YouTube account, creating and posting the videos referred to above. He also admitted to sending the emails to Detective Gatwood, all caps, referred to above. The accused made admissions to owning the pistol and stated that he had purchased it from a friend some time ago. The accused continued to assert that the laws of both the Commonwealth of Australia and the state of New South Wales do not apply to him. Firstly, I noticed just by this last comment is that there's a flip between Australia and the Commonwealth of Australia, and there's this flip between the state and New South Wales, state of New South Wales. That there's this using of every attempt of language. There's all caps Gatwood, there's spelling mistakes. It's a hodgepodge of all types of different language use during either a process in time or an officer using this on purpose to try and detract from your ability to defend yourself against their actions, which, as we've seen, is about reprogramming your mind. It's all about reprogramming you with their doctrine, or indoctrinated into a state mindset. So we carry on going through. It's the formation of offences now and the evidence that they relied on to enact these offences in the first place. And they have obviously dragged him into a police watch house and sat him down for an electronically recorded interview on a suspect person, ERISP. 26. In his ERISP on 30 July 2020, a transcript of which was tendered, a long, largely incomprehensible, rambling series of answers were provided to questioning police. The defendant denied that he was inciting people to violence. stating, open quote, "I'm telling people not to cower in the corner at the side of police, to stand up to the police, but at the same time, do not raise a hand against the police. Don't be belligerent," end quote. 3. eRISP interview, Ewa Kiskonen, dated 30 July 2020, page 25, paragraph 25. Now, I haven't seen all the evidence that was submitted. I could not be bothered reading 2,500 pages and watching 13 videos that would have taken 13 hours to watch. The unbelievable thing is that the police honestly believe that the court's going to take the time out to adhere to the thousands and thousands of documents that have been put before the court, wherein the police have spoken in a manner that is completely biased to the evidence. 27. He was also asked whether he believed police should be hanged, to which he replied, no. Now, on the matter of hanging, that's capital punishment. And at a federal level, no, we don't want capital punishment reintroduced as law in Australia. But we're not talking about Australian law. We're talking about the international laws of armed conflict and international humanitarian law, at which you are the ones in guardianship. You're the ones that took an oath. You're the ones that sipped from that poison chalice. So is it capital punishment? No. He is directly correct when he speaks of a military tribunal. He is also correct in that they're international rules that are internationally agreed upon. And to go outside of those rules would, as the United Nations knock on your door and you deny them visitation, become an international embarrassment and possibly an international problem that could open the door to warfare. And you might be doing that on the ground at a street level. 28. He was asked questions about the role of the, quote, military tribunal, end quote. He was referred to question 217. I was just going to ask, what would happen to one of your members if they acted outside the military tribunal? If they went ahead and hung the police? Who's asking the question? Is it you, Detective Senior Constable Reason? Answer. Oh, they wouldn't be one of our group, that's for sure. Question 218. Is there some sort of repercussion? Answer. Yeah. They would face a military tribunal themselves and probably lose their head. Question 219. Through you guys? Answer. No, through you guys. And then question 220 goes on to the next page, so we'll entertain it when we flip slides. An example on the table. In modern history, Slobodan Milosevic would probably be one of those examples. He was jailed at The Hague. He was taken to The Hague for his international criminal offences. This is something that has a credence in history. It has changed over time, including things like Nuremberg trials that have affected it. And it's a general consensus between countries to act in a certain way. And when they're put into conventions and treaties, there are reasons for that to occur in the first place. And the ignorance of an employee or agent that just follows orders from commanders who may or may not know, who give or issue orders, is directly relevant. just following orders was no excuse at law. And when it comes to what will follow soon within this affidavit, this preliminary hearing, will outline the very reasons, in my belief, New South Wales denied access to United Nations visitation into its facilities. The Dangerous and Slippery Slope is Fixated Persons Unit acting as State Protection Squad and using forensic psychiatry in a bid to change people's minds over their beliefs. And very clearly in the wording in the documents so far have we seen a very direct attempt to use these avenues at law to enforce a situation rather than reveal one. It is as if the police are creating something that isn't there for fear of something that is there. That's a dark slope to slide down if you let that happen in your courtrooms. And Justice Julia Lonergan is very starkly pointing it out. It's a credit that the document has been made publishable in all its aspects, because this is a very key point in the turning of what is a crime into pre-crime, into the abuse of the state, and comprehending and understanding from a historical point of view how then from a legal point of view things happened, into a spiritual point of view over why these things happened and over what, demonstrate that standing in international law very clearly. And it cannot be understated in that a recognition at some point that this is an administered territory and you're working for administrators that have administrative duty over the state of New South Wales. Continuing on with the ERISP report, Detective Senior Constable Reason, question 220 at 11:39. A military tribunal? Answer. We're not here to fight with you. We're not here to argue with you, but you people have to understand that we're standing in our lawful capacity, and you people as a foreign military have to respect that. You have to respect that, otherwise it's a war crime. This is what I'm trying to get through to you people, is that you have to respect the law, international law. I'm standing within my international law, and I'm adhering to the laws that I'm obligated to adhere to, and so should you. If you cross that line, you should be punished. If I cross that line, I should be punished. If people want to take that law into their own hands, they should be punished. I'm not here to I never once told anybody to rise up against the police violently. I've had spelling mistake, interactions with the police at the Shrine of Remembrance in Melbourne at Mawson Park. I mean, I'm sure you have access to that video footage. You will see I was completely peaceful. I was non-belligerent. I didn't argue with them. I just told them how it was. And when I laid it out, for instance, the Fourth Geneva Convention of 1949, Chapter 5, Article 93, which states that you, the foreign military, have to allow us, the peaceful civilians, every latitude to attend the military, to attend a religious service of our faith. The people of Melbourne and the people in Campbelltown adhered to that, and they left us alone. For eRISP interview, Ewa Kiskonen, dated 30 July 2020, paragraphs 29, 28. 29. This eRISP should be read against the background of the defendant's articulated position in an email 7 May 2020 sent to Detective Senior Constable Gatwood that was not the subject of a charge, which included these propositions. Hi James, you will find attached several papers you should take the time to read. They lay out a number of things of importance pertaining to the military occupation of our Kingdom of Australia and a foreign crown pretending to be our proper crown, which you serve. These papers are unrebuttably accurate, and you should take the time to read them. Feel free to try to rebut them. A retired magistrate has even read the two, titled Realm and ... and agreed they are indeed correct. Now I know you have been watching the videos I have posted, and for our conversation today, I see you are at least checking that I know what I am talking about, and I appreciate it. Thanks. Good to know you're paying attention. When do you read through the Australian Treaty Series, in particular Hague 4, Customs of, spelling mistake, War on Land, you will find that this is the primary document that allows for our military occupation, and Australia Day actually represents the day that that treaty came into effect, being, spelling mistake, our official military occupation. Article 1. The contracting powers shall issue instructions to their armed land forces which shall be in conformity with the regulations respecting the laws and customs of war on land, annexed to the present convention. This would include the Lever Code as the regulations or field manual that you must follow as the occupying force. As a subsidiary of the United States, technically, although now controlled by the United Nations under the Crown of the United Kingdom of Great Britain and Northern Ireland, being the St. Edward's Crown. I also included a somewhat detailed paper I put together titled Timeline, which points out key historical events that led, spelling mistake, to where we are today, ... Have fun proving that wrong also, ... end quote. There is other correspondence in similar vein later in May and in June 2020. What is clear is that the police are trying to skew it as if the responsibility lay with Dewar, when the responsibility actually lay with themselves. And pointed out very clearly is these links to these international obligations at which one side was at least attempting to abide by. And the other side, if you could call them sides, at which we've already acknowledged in this document, the other side hasn't abided by these. Now, there may be some ignorance in both parties here, but the general consensus at the moment is that within a time frame there was ample opportunity to deal with evidence in a manner that would have shown a lot more professionality from the police's side. To me, it looks like they've just hashed all of this together at the last minute, thinking that they could get the upper hand over something that is a little bit more in-depth at law. This game of thuggery needs to stop, because there have always been questions at law. And those questions, the longer they remain unanswered, give credence to everything that's said. And that's the one thing that needs to be, I suppose, acknowledged in this. It's like the elephant in the room that everyone doesn't want to address, is that there are core foundational facts that are, and answers should be forthcoming, rather than the fist of fury of the state. Now we move forward into some barrister comments or solicitor or lawyer comments from the police prosecution side. 30. Senior counsel for the plaintiff, Mr. Emmett, placed emphasis on a particular recurrent gesture he says that the defendant made in some of his YouTube material. In a presentation on 27 July 2020, the defendant outlined certain activity that was to take place on 31 July 2020 and made reference to a document that, open quote, has not been released yet, close quote, and then says this, open quote. And as I said, it puts the police on notice. So whether they chose to take notice of it or not, it certainly puts them on notice. And if they choose to go against that, well, hey, it could end up, being a bit of disaction for them. 0351 makes gesture. Or, actually, I'll say it would more than likely end up being that sort of action for them, because they're armed. They're a foreign military and they're threatening the peaceful civilians. And we don't care. Well, not that we don't care, but there's fair enough. There's nothing that we can do for citizens, but don't go messing with our people anymore. The people that are under this flag. So if you see this flag, Mr. Police Officer, I suggest you walk the other way, like you do with me most of the time, close quote. And later, in the same presentation, open quote, ... But you police officers that know that you're doing the wrong thing now and you continue to do it, well, I can understand the fact that you did, that you need to honor your oath, but you can change that just by making another oath. Your oath back to God voids all other oaths. You're serving a foreign crown, a foreign God, against your own people. And you have the power of changing this. And only you have the power of changing it, because you're the ones that are in control of your allegiance, where your allegiance lays. So all you police officers that do watch, and I know some of you watch, you really need to make a decision as to where your loyalty lays. And you need to realize that when you know that you're committing treason and you continue to commit treason, open bracket 1452 makes gesture, close bracket, it does lead to that. If not by military tribunal, say if the military tribunal does nothing about it, when the king gets control of the country whole country again, and we get rid of the occupier, where are you going to be left? All you police officers out there, when the occupier leaves, are you going to leave with them to avoid hanging? Bad English now. Or are you can think that you're going to be able to stay here and avoid hanging? Question mark, ... close brackets. 31. Mr. Emmett also drew attention to this part of a similar YouTube presentation in May 2020. Open comment. ... We're going to give everybody a choice to be loyal to your kingdom. Make your oaths back to the Kingdom of Australia, or there will be consequences for your treason. And yeah, the consequences will range from mild, being you're going to leave this country, you're going to leave it behind, and you're going to have no recourse to very strong. And that is that some of you might find, open square bracket, 0326 makes gesture, close square bracket, a rope getting very tight around your neck, and your feet dropping out from underneath you, and that rope going taut and snapping your neck. Now I know I say that very callously, but believe me, there are some of you that deserve it, and those of you that deserve it will be getting it. Some of you might only be spending your life in jail, like Ivan Milokovic, I think his name was, for war crimes. So things are changing. 32. I was informed by Mr. Emmett that I did not need to watch the YouTube videos, but the gesture each time was a physical gesture consistent with hanging. Observations regarding the defendant's mental health and the basis of the Community Treatment Order, CTO. So we'll go into that in the next slide, but this is where they start to question the beliefs of someone after already using that language themselves in their own statements that are presented to the court. It could also be said that the fixatedness of Fixated Persons Unit in their 2,500 plus submission of pages, along with umpteen hours of video evidence, would demonstrate that they had a modus operandi to turn something that was peaceful into something that wasn't. And this could be construed as far as infiltrating to the point of attempting to drive that inciting of violence themselves from within those groups. The evidence that's laid out so far doesn't give any credence whatsoever for the police to show any concern for the events that happened in July of 2020. Quite the opposite. They have literally confirmed what was lawful and peaceful, something it wasn't, by the very police themselves, at which Matthew Reason admits to being the one who took command of the situation, putting this all squarely in Matthew Reason's lap and those that gave him the command responsibility. Before we get into these observations, let's just observe something in return. So a progression of events led to Matthew Reason joining the Fixated Persons Unit, wherein he observed certain actions by a certain group because they were Facebook involved, targeted before a memorial event wherein a flyer was created along with memorial, including prayer and raising of a flag in memorial of Anzac at which Ua Kiskonen was singled out among hundreds of people and subsequently arrested under very spurious circumstances involving a toy gun. Matthew Reason admits to taking command. Matthew Reason admits to contacting other cities to inform them of participation, and lists 8 or 9 cities in which participation occurred without incident. Ua is then sent to Silverwater Corrections Facility, if I remember correctly. He is then assessed by this mental health review tribunal within 3 weeks of being out on the street for trying to remember Anzac, to being put into jail for spurious circumstances wherein he's thrown straight before mental health review tribunal. 33. The defendant was referred to the Mental Health Review Tribunal, MHRT, shortly after his arrival in custody. In a report of 8 September 2020, the psychiatric registrar from Justice Health stated that the defendant had been referred to the Mental Health Screening Unit in the context of a, quote, a deteriorating mental state, end quote. This is a matter of weeks, like 3 weeks, 3.5 weeks, that this has occurred at the hand of the state. That this is the power of the state against anybody on the street that has an informed and educated history that may contradict that of the state. 34. On 10 August 2020, the defendant was reviewed by staff specialist psychiatrist Dr. Keating. She was asked to see him in the context of a recent hunger strike and to examine whether he was psychotic. She noted the following, open quote, ... went into long detailed conspiracy theories which made it difficult to elicit other history, very fixated and preoccupied by these ideas. For example, I'm of a different jurisdiction. You only have to research international law and read The Hague. That treaty specifically deals with military occupation of this country is under illegal military occupation by the United Nations. I was going to expose it, so now I'm being victimized. The next paragraph goes off slide, so we'll address it in a second. There are selected quotes being taken from, by, at this point, a justice of the Supreme Court who is demonstrating that a certain psychiatrist has made a report in writing, and there are obviously certain claims, because we can see in the next sentence it goes on to the United Nations Roman Crown. There are going to be ignorances or lack of knowledge on all parties. That's what my statement's going to be, in that there is a large range of knowledge that would put down that foundation in the first place. So my point of view here is that all parties are going to be shown to be ignorant at this point. Over to the next slide. They, bracket, police, bracket, mocked me, ... because of what I know, the government, which is IS, the United Nations, and also the police serve the Roman Crown. It doesn't belong in this country. It's actually unlawful under the Act of Supremacy 1688. I asked what the Act of Supremacy is, and I said, I've never heard of it. They don't want you to know it, that's why. There are two different constitutions in this country. One that puts people over the government, and the other puts the government over the people. They don't want people to know their true lineage, their crown, the imperial crown. All started when, I found out the fact that the Australian government isn't who they say they are 6 years ago. I took my neighbour to court, which I did myself because I like to do things myself. Then starting researching the law, that's when I started to realise it all. Found it to be 100% irrefutable and correct. They want to shut me up. When I wasn't so popular on Facebook and YouTube, they didn't care. But now that my message is getting out there, they're getting worried about me. Reports more than 5,000 followers on Facebook, but I'm working with other people that are targeted as well. And later in the interview, RE charges, using a carriage service, I sent an email to a Detective James Gaddard of the Fixated Persons Unit after he mocked me and mocked the information which I shared with him, which is irrefutable. If he is going to mess with the loyal people of this country, he will probably hang. Firearms offence for a gel blaster like a paintball gun, not illegal in other states, denies intent to use it to harm others. They offered me legal aid, but I can't use them. If you read the lawyer's handbook, you will read that all lawyers' first duty is to the court, so how can you trust them? So those are not Jewa's comments, so they are the notes in the doctor's handbook that she wrote at the time of her interview with the defendant, or post that interview, when she made post-interview notes. And those notes have been put on the record. So that is a staff special psychiatrist, Dr. Keating, that has put these notes in a notebook, and the Justice has now put them on the record. 35. Dr. Keating concluded her report as follows. Quote, 50-year-old man with minimal psychiatric history presents with escalating delusional ideation over several years, accompanied by some grandiosity, no other clear symptoms of psychosis or major mood disorder. Note, history of bowel CA, with possible signs of recurrence 2 years ago. Need to exclude organic cause of current presentation. He acted on his delusional beliefs by making threats and disobeying legal directives under the belief they don't apply to him, which has caused harm in various domains of his life, particularly his relationships and his reputation, and now leading to legal sanctions. Recent risk to self via hunger strike, however, now eating and drinking. It sounds like mummy looking after a child, doesn't it? Because that's basically what the state is trying to emulate here, is that they're your guardians. So this whole concern is about you being treated as a child. 36. Returning to the September 2020 report from the MHRT, the registrar recorded that the defendant did not have a history of mental illness prior to custody, but that he had a systematized paranoid delusion that there was unlawful military occupation of Australia, and that there are two constitutions of Australia. And due to these beliefs, he believes that police officers should be hung for war crimes. He also has had grandiose delusions that he is the mayor of Campbelltown and had been putting flags around the suburb. He described the defendant as being very guarded about the psychotic beliefs and that he refused to engage with the treating team. He apparently had repeatedly told nurses he was going to be released within days and that has friends in very high places. The registrar concluded that he was insightless into his persecutory delusions and was a high risk of harm to others if his beliefs are challenged. At the time, he continued to refuse psychiatric medication. The registrar concluded that the risk to others was due to his untreated mental illness, and so he was transferred to Long Bay Hospital for involuntary treatment. Now, the Justice has not mixed her words here. This is a very, very important statement that's been left on the record by Justice Julia Lonergan, because very clearly at the beginning there is no history of mental illness, but at the end of this paragraph he's being transferred to a different hospital for an untreated mental illness that is, by the words of the registrar, a systematized paranoid delusion. So he disagrees with the state, although that not be unlawful. He disagrees with the system at which this team would be liable for international humanitarian law under Rule 90 and Rule 92. Because by the end of this paragraph, within the first weeks of his incarceration, he is being transferred to Long Bay Hospital for involuntary treatment. That sounds very suspicious to me, that someone could go so quickly into that after being found to be clear of any mental illness before entering into the care of Silverwater Corrections Facility, at which the United Nations were recently denied visitation to inspectors into those facilities, not specifically Silverwater, but New South Wales Corrections Facilities. 37. Documents from the MHRT in early September 2020 noted the grandiose delusions against a background of systematized paranoid delusions. The MHRT agreed with the need for enforced treatment. So we have now a tribunal outside of law that have gathered together to agree on behalf of Dr. Kansu, Registrar in Forensic Psychiatry, has signed off on what follows. 38. A more detailed report of Dr. Kansu, Registrar in Forensic Psychiatry, dated 19 October 2020, was prepared for a later hearing at the MHRT. This included detail that the defendant, despite denying he had any admission to psychiatric hospital or having ever been prescribed psychiatric medications before, had been admitted to Waratah House in September 2015 following an overdose, although at that point there was, it seems from the discharge summary, no sign of a mood disorder or psychotic disorder at that time. So these doctors have tried to dig into the past of the defendant in a bid to scramble together a reason or purpose for their actions that they've done in the month before. And this report was prepared for a later hearing, so it's not the hearing that was used to transfer him to Long Bay for involuntary treatment. So we've gone from flimsy excuses on behalf of fixated persons into involuntary treatment within a facility within weeks. And this is exactly the torture that the United Nations is specifically talking about. 39. Dr. Kanzu's report made reference to information obtained from the defendant's de facto partner that the defendant had, quote, become increasingly preoccupied with online conspiracy theories, withdrawing from his family and becoming more grandiose and unable to be challenged, close quote. And when he was challenged, he, open quote, would become verbally but not physically aggressive, close quote. The de facto partner also outlined certain behaviours on the part of the defendant that Dr. Kanzu thought may be features consistent with a narcissistic personality disorder. So these are comments put on the record, defined by Dr. Kanzu during a report dated 19 October 2020, wherein Dr. Kanzu makes those allegations. 40. It was noted that the defendant had been on a hunger strike when he was first incarcerated due to his systematized delusional beliefs, believing he was a prisoner of war unfairly imprisoned. It was noted that he possessed poor insight into his condition and had not been consenting to his medication in the beginning, but was at the time reluctantly compliant. Not consenting, being reluctantly compliant, for what purpose? That's I can see that a man has been incarcerated, and there are considerations during that incarceration, but there is no purpose here other than for him to not go into that general population and speak, because he was adamant in his convictions. 43. The report of the MHRT dated 5 November 2020 relied upon the treating report and concluded that it was satisfied that the defendant continued to suffer from mental illness and required further inpatient treatment at the Long Bay Hospital. A further review was scheduled, at which time a Forensic Community Treatment Order, FCTO, would be discussed. It was noted that the defendant said that he would not take any medication which would, quote, change his metabolic state, end quote, but he did not explain what that meant. At that time, the MHRT noted that the defendant was taking olanzapine, which had recently been increased to 7.5 milligrams per day, and which was at the stage being administered by injection. a forensic community treatment order. So this is an inmate of Corrections New South Wales being treated like they would be an ongoing problem in the general community after their release, which was leading up to this moment where this paper is being laid out. It links very succinctly a chain of events in a line of command that has rushed very quickly over the course of 4 weeks from being arrested by a fixated persons unit to being drugged and incarcerated and sent off to Long Bay Hospital, which is a corrections facility itself. 44. On review of 23 December 2020, Dr. Sharma, staff specialist psychiatrist, the defendant, said that he no longer believed the things he had previously stated about the government not being legitimate and Stephen being the King of Australia. Dr. Sharma recorded as her, quote, impression, end quote, that, quote, he no longer holds his prior delusional beliefs with the same intensity, but it is not certain that he has become well enough to simply disguise his underlying beliefs, end quote. So again, this is a justice putting a doctor's note on the record that this is the belief of the doctor about the government not being legitimate and Stephen being the King of Australia. These are not my words. I have never used these words. So these words are there in front of everyone to be seen. I didn't ever make that claim. 45. In an assessment by treating psychiatrists at Long Bay Hospital in January 2021, prepared for a further MHRT hearing, the treating team noted that it had received registered post from one of the defendant's, quote, followers, end quote, telling them that they must release the defendant as he is being held illegally and pleading his case to the Commonwealth Minister of Health, Greg Hunt, and that the defendant had said that he had been instructed in his views by, quote, Stephen, the right and truthful King, end quote. 46. The assessment report concluded that overall the defendant had shown improvement in his mental state, but was still insightless and, quote, only reluctantly, end quote, accepting his medication, and concluded that he was suffering from a, quote, delusional disorder, perhaps late onset schizophrenia, bracket, but possibly with an organic disorder, end bracket, being a mental illness characterized by persecutory, grandiose, and bizarre delusional beliefs, end quote. It is also noted that he had shown significant improvement in his mental state, but there was risk of relapse, and so the FCTO was requested to be put in place before release into the community. The report also concluded that he will, quote, continue to benefit from his antipsychotic medication and further investigation of his medical condition, as well as ongoing psychoeducation, end quote. There is a real want to further what needs to be noticed through all of this is that these are doctors with inside a corrections facility, which has led to this obvious speed at which this was all enacted, and the end result from a man of good faith into being tortured within the distinct boundaries of international humanitarian law at Rule 92, because now we've come down to this. It's a report dated the 5th of November 2020, wherein it states he had his olanzapine increased to 7.5 milligrams per day, at which they were being administered by injection. We also have an admittance that this was done against the will of the defendant, with an admittance in writing that this was no longer voluntary. It had become involuntary in nature. We consider too that this forensic community treatment order has been denied. We know that from the beginning of the document. Carrying on with this medical evidence, 47. In January 2021, a forensic treatment plan was formalised, which included monthly meetings with his psychiatric case manager in the correctional centre, a 6-weekly meeting with his treating psychiatrist, a requirement to accept treatment and medication as prescribed, and to provide regular urine drug screening samples and to comply with necessary blood tests to provide for metabolic and clozapine level monitoring. Definition: metabolic, adjective, metabolic, relating to or deriving from the metabolism of a living organism, a metabolic disorder. 48. The last review available in the evidence tendered where the defendant was actually interviewed and assessed was 22 June 2021 by a CMO, Dr. Andrew White, who noted, open quote, "Today he presents as somewhat dishevelled, but was woken from sleep to see me. He was pleasant and polite and cooperated with the interview. He said that he no longer believes the things about the Australian government or other conspiracies that he previously did. He admits to becoming completely preoccupied with these beliefs and that they had taken over his life and damaged his relationships. He attributes his change in mental state to the shock of incarceration and his wife ending their relationship, and does not think that the medication has helped in any way. Medication makes him dumbed down and tired, but he feels better on his current regime than he did when he was on more RX, accepts his diagnosis and was able to label it as delusional disorder, accepts that he was completely overrun by his conspiracy beliefs and accepts the label of delusional. Denied any ongoing interest in pursuing his conspiracy theories. His plans on release are to go back to work and attempt to reconcile with his wife. Said that family is the most important thing and he wants to do the right thing by his family. will continue to take RX because he knows he has to, and police and PMP will require him to take it. Also admitting to smoking THC prior to custody, he won't do that anymore because he doesn't want to go back to it, and he is also aware of parole conditions. Plans to go back to live with his ex and kids, boys in their 20s. IMP. Implied delusional disorder seems most likely diagnosis, probably on B/G of narcissistic/paranoid PD and THC use. So do you fit inside their box? Because that's what this is. We've had at this time a year of incarceration. We've had 12 months of being drugged. We have an interview with the Dr. White where the patient is admitting that this is not helping him. This is the forensic mental health inside New South Wales jail systems. This is a large evil that the New South Wales government will not address. And given that the United Nations have knocked on their door, and given that they have taken these actions very specifically against a very specific belief, an attempt to brainwash that person from believing certain things, demonstrates a modus operandi of the state itself, at which these police officers know they have an upper hand when they can induce this kind of reaction from their very own actions. Right, moving on. A summary of the positions taken by the parties regarding the statutory preconditions. So the police and the state have tried to enact a further monitoring and drugging of someone that should never have been drugged in the first place on their eventual leaving of the jail system. A summary of the positions taken by the parties regarding the statutory preconditions. 1. The plaintiff. 49. The plaintiff argued that the requirement of Section 27A of the Act are met given the defendant's current sentence of imprisonment is due to expire on 29 July 2021, and the sentence of the imprisonment was imposed for a New South Wales indictable offence, the firearms offence arising from the gel blaster gun found at his home. The indictable offence was the searched for offence, wasn't it, Matthew Reason? And the moment you found a toy gun, you went over and above where Section 109 of the Constitution could be brought into play, in that these laws exist in other states that make those toys legal. Does the state have the right to legislate over the people? There is a good question in that in itself. Who is the state? But this problem arises from a toy gun. This is not a real gun. This is not a gun that any terrorist organization would employ in a terrorist type activity, Matthew Reason. And you full well know this. 50. The plaintiff submitted that the court would be satisfied that the requirement of Section 27B have been met because the matters alleged in the supporting documentation would, if proved, justify the making of an ESO. If proved, it was emphasized that the court must take the allegations and documentation at its highest, and it is not for the court at this stage to weigh up documents or resolve any conflicts or inconsistencies which appear in the documentation, nor to predict the ultimate result or consider what evidence the defendant might present at final hearing. 51. The defendant is a, quote, convicted New South Wales terrorism activity offender, close quote. Having regard to the definition of that term in SS 10I and 10(1)A of the Act, because he has previously made a statement advocating support for violent extremism or has previously had personal or other affiliation with a group or organisation that is or was advocating support for violent extremism, Section 10(I)(c) of the Act. We already know that this was shot down in a ball of flames, but the fact that the plaintiff has used the term convicted New South Wales terrorism activity offender when this is not specifically and actually true is a discolouring of the law instead of the spirit of the law. It's not even the letter of the law. 52. Having regard to the broad meaning of, quote, violent extremism, end quote, that captures conduct that might not satisfy the technical definition of a, quote, terrorism act, end quote, particularly matters were identified, said to be evidenced in the documentation supporting the plaintiff's application, which would, if proved, amount to advocating support for violent extremism for the purposes of Section 10(I)(c) of the Act. So we'll go into these bullet points in the next episode, but we can see that there's a direct attack here, and it's there for a reason, and the language that's being used is specific in its purpose, but it doesn't detract from the fact that there are those international humanitarian laws on the table, and there is somewhat an obligation at a federal level, which is why there is such a diplomatic incident with relation to the United Nations being denied access to New South Wales facilities. Bullet point. The defendant making statements to Detective Senior Constable Gatwood, including that, open quote, breaking the rules could cost him his life, end quote, and the references to hanging, which are in effect threats of violence that are promoted by a person, group, or ideology that supports violent extremism, namely the UKOA. The police have a serious notion of threat from this UKOA. They have sought to attempt to bring it into a terrorism organisation that has ideologies and is violent extremists. They just paint anybody they don't like with a tarred brush. This is who they are. This is what they do. Bullet point. What was said in the email in July 2020 regarding, open quote, holding to account under military jurisdiction, end quote, any police officer that, open quote, tries to force themselves onto me, end quote, and, open quote, I'm sure I don't have to point out that war crimes may be punishable by death, and the Nuremberg trials will tell you that following orders will not protect you from a rope around your neck, end quote, amongst other statements. Bullet point. The YouTube video on 27 July 2020 that included comments implying that certain police activity was treason, that the police are, open quote, a foreign military threatening peaceful civilians, end quote, and that police should be exposed to the punishment of hanging. 53. It was submitted that the fact that the threats appeared to contemplate some form of court or tribunal proceedings, first occurring before the punishment of hanging, does not deprive from the propositions expressed of their extremist character. This is where you ask Matthew Reason if he'd like a bucket of feathers as well, because that's all he's doing. He's attempting to tar someone with a label that he and the state can then further label the label. 54. In terms of assessing whether there was an unacceptable risk of committing a serious terrorism offence, the plaintiff emphasised the facts giving rise to the Commonwealth offences which stemmed from the defendant's ideological connection with the UKOA movement. The ideology evidenced in his social media postings, as well as his poor mental health. It was argued that the material referred to in the Facebook posts regarding the activities of UKOA and that movement's ideology comprised statements consistent with the use of violent extremism to achieve their aims. This is in turn consistent with what the defendant says in his own Facebook and YouTube posts. Notice how it's all Facebook? This is just what I want to point out. It's all Facebook. Half the people on Facebook are the police. 55. Although recent communications between the defendant and his Justice Health mental health team appeared to include disavowal of his previously expressed beliefs, recorded conversations between the defendant and UKOA members, 18 February 2021, suggests that he still maintains those beliefs. 56. I interpolate here to observe that I'm not persuaded that those phone calls form a solid base for that submission. There are statements made in those calls by the defendant that suggest to the contrary, and the calls were almost 5 months ago. Neither side of the police's statement can be in any way true, if that's the case. Definition. Interpolate. 1. Insert something of a different nature into something else. 2. Interject a remark in a conversation. 57. The plaintiff submitted that concerns regarding mental health comprise the nature of the defendant's mental illness. The prior history of compliance with medication and his failure to comply with supervision by community corrections, as well as his lack of insight and impaired judgment. There is a whole entire statement made up of words directed at the mental health within that correction facility that were then backed up by that mental health in that corrections facility. You can see how these are direct usages of the words within those documents. 58. The written and oral submissions made on behalf of the plaintiff then descended into a level of complexity which it described as potential, open quote, risk scenarios, close quote. The complexity of these potential and in some ways speculative scenarios, to my mind, underscore the speculative and uncertain nature of the risk allegedly presented by the defendant that he will commit a serious terrorism offence. The complexity of these potential scenarios, to my mind, they are complex. And this is where she's pointing out to the police, do you really know who you work for? 59. The first scenario was said to comprise the defendant continuing with the conduct of the kind engaged in prior to his arrest and incarceration, and the second, the risk of escalation of his conduct. 60. It was explained that the first risk was the defendant's previous threats of hanging authority figures, including police, as threats of action that would fall within the definition of, open quote, terrorist act, close quote, in section 100.1(2) of the code, but not subsection 3. These are threats of an action that would result in death, and are threats made first with the intention of advancing a political or ideological cause, and second, with the intention of influencing the police or other public figures in the performance of their duties. It was argued that the defendant's, open quote, continued adherence, close quote, to these previously expressed beliefs indicates a real prospect of him resuming conduct of the kind engaged in prior to his arrest. So there is a significant likelihood of the defendant engaging in conduct that constitutes a terrorist act being an offence contrary to section 101.1 of the code. And all these years, people have thought it's normal to be bullied into submission by the state. 61. The plaintiff accepted that the threats of violence are stated to only occur following the regime change for which the defendant advocates, but argued that this still satisfies the definition of, open quote, terrorist act, close quote, and while the likelihood of threatened hangings might be low, and while the defendant may have had no intention to encourage immediate acts of violence, such threats are significant because they might, open quote, create a milieu which fosters the prospect that personal injury will be suffered by innocent members of the community, close quote. Definition: milieu: the people, physical and social conditions and events that provide the environment in which someone acts or lives. 62. Alternatively, it was submitted that the defendant's conduct in publishing the videos on Facebook containing the material described above may lead to offences contrary to section 101.5, collecting or making documents likely to facilitate a terrorist act, or section 101.6, doing any act in preparation for planning a terrorist act under the code, particularly as the defendant is only required to be, open quote, reckless, close quote, as to the connection between his conduct and a terrorist act in order to establish those offences. I'm still not clear as to what offences. The direct accusation that he's going to hang someone or not. 63. The plaintiff argued that the connection between the videos of the kind made by the defendant and the commission of a terrorist act is a real one, given that those videos identify persons said by the defendant to be a legitimate target for retributive violence. Whether this is the judge's words, I think it's the police's words, retributive violence. Retribution for what, Matthew Reason? There's a key point there in that you've done something very wrong and you believe now that the violence would come back on the state in a retributive form rather than the initial form in that you're a fucking war criminal. 64. Whilst there are disavowals of violence in the material, these disavowals occur alongside statements such as, open quote, got to start carrying out action to deal swiftly with the foreign administrators ruling over our country with no rule of law, close quote, and open quote. I have now given you enough evidence to crucify this man, close quote, and open quote. No one is truly prepared for what's coming, close quote. No one is truly prepared for what's coming. And what has happened in the time since? Is everyone watching the world around them? 65. I interpolate here, in regard to these statements, that I do not see any of them as having sufficient clarity of proposed action to amount to a, open quote, call to arms, close quote, for violence. Interesting use of the word call to arms there, Justice Julia Lonergan, because what is a family coat of arms, everyone? It's a call to return. It's a call to come home. 66. Regarding the second risk scenario, the plaintiff submitted that the risk assessment report author has concluded that the defendant is, open quote, vulnerable to acting or engaging in violence to achieve the goals of the UKOA if the narrative was to shift towards the people of Australia adopting roles within the kingdom that is creating perceived legitimacy for engaging in violence, warfare policing, and or military jurisdiction, end quote. That's a very interesting statement to make that we shall look into a bit later. 67. The plaintiff submits that the risk is unacceptable given that the defendant had previously made threats to police officers that may reasonably be interpreted as death threats. That may reasonably be interpreted. That's a way of saying anything you say can be interpreted as a threat to me. 68. His previous non-compliance with the CCO, which occurred back in May 2020, was premised upon his ideological beliefs. This is cited as evidence of risk, as is his reluctance to engage in mental health treatment. His criminal history involves some violence and some past difficulty with anger management based on information provided by his de facto partner. These two are said to be matters that heighten risk. There's a lot of hearsay just in that 68 quote alone. The cited evidence, the words coming from people that are third parties, gathering all this hearsay together, is not actual fact. And they could be based on lies. 69. It was submitted that the court should place weight on the conclusion by the risk assessment report author that he is at, open quote, moderate to high risk of engaging in politically motivated violence, end quote. What we've noted from the report so far is that it is Matthew Reason that has the interest in the violence. He's the one that called the police of all states in defense of the war memorials. I wonder why that is, Mr. Reason. 70. He was not compliant with his CCO. There is a risk that he may not comply with his CTO. His beliefs and commitments amount to a type of, open quote, call to arms, close quote, to others with use of social media posts. He has some influence as a, open quote, leader, close quote, of the UKOA movement. Something doesn't make sense there, Mr. Reason. Something to do with God. 71. In broad terms, in relation to the relevant S25 factors, before incarceration, his behaviours were escalating, as was his level of fixation and obsession with, open quote, the cause, close quote. His delusional belief system regarding the legitimacy of the Australian government has real capacity for risk that he will either engage in activity or disseminate extremist ideology to radicalize and influence others. 73. I note that there is no evidence that the defendant was receiving any mental health treatment or support at the time of 2019 or 2020 offending. So that concludes the roundup of the plaintiff's argument noted by Justice Julia Lonergan. And what we can see is that there is a direct hatred towards what is now named and titled on Supreme Court record. And I will clearly say it is not the UKOA. It is the United Kingdom of Australia, as forged by your Anzac at the international treaties leading to imperial conferences, leading to a blessing of Almighty God. And it's that argument there that is not even brought up by this policy group. 2. The defendant. 74. The defendant submitted that first, the statutory preconditions in the Act have not been met. Second, the court would not be satisfied to the necessary degree that the defendant poses an unacceptable risk of committing a serious terrorism offence, if not kept under supervision under the Act. It was also submitted that third, the court would not be satisfied that the matters alleged in the documentation would, if proved, justify making the ESO. There's several layers here in that the police have not proven that any terrorist organisation, terrorist act has taken place or exists. They have not proven that there's any risk of violence. And then thirdly, they haven't proven why someone should be watched by the police continuously. 75. It is significant that the offending for which the defendant was sentenced under the code was relatively low level, in that it was a simple offence of using a carriage service to menace, harass or offend, rather than the type of offending in Chapter 5C of the Code, urging violence against the Constitution or against groups or advocating terrorism. 76. Whilst the defendant's possession of an unregistered gel blaster was sufficient to qualify him as an eligible offender, the nature of the offences weighs strongly against the order being made. That says something about the legislation created by a parliament in relation to toy guns. 77. There were submissions made about whether the service requirements under the Act had been met and whether there had been disclosure as required by the Act. But these matters were in my view faintly pressed, and the application was defended on the basis of the material being properly before the court. 78. What was pressed, however, appropriately in my view, was the problematic bases of the psychologist's risk assessment report relied upon by the plaintiff, purporting to calculate the likelihood of the defendant committing a serious terrorism offence. This report of Miss Prince was heavily qualified, referring to itself as a, open quote, interim assessment, close quote, only, and concluding that any risk presented by the defendant required a narrative shift occurring before any such activity would proceed, and it would be activity in which his role would likely be limited to promotion, recruitment, and development of material. It was in this context that she assessed the defendant as presenting a, open quote, moderate to high risk, close quote, using the Violent Extremism Risk Assessment Tool, VERA. There was nothing in the report, however, that assessed the likelihood of the contextual change of or narrative shift actually ever occurring, and so her conclusions remain speculative. Pre-crime is the way I have described it. These speculations that are allowed on behalf of the police when they're applying in a court, but are not allowed on behalf of the defendant when defending himself against such spurious accusations. 70. The defendant disputed that he should be correctly considered a, open quote, convicted New South Wales terrorism activity offender, close quote, even under the extended definition set out in Section 10(1)(a) of the Act. 80. Section 2 of the Act sets out the matters the court may consider in determining whether the defendant is in fact a convicted New South Wales terrorism activity offender. 81. First, the sentencing magistrate specifically declined to sentence the defendant on the basis that he had an allegiance to a particular group. Second, evidence adduced on sentence did not properly lead to a conclusion that he was either making a, open quote, call to arms, close quote, to his associates to hang police or engage in any act of violence. In fact, there was a number of statements that show an intention to act peacefully and that he expected others to act peacefully. Third, there is no relevant terrorism intelligence. The material in the affidavit of Detective Senior Constable Reason is not a report relating to terrorism or a terrorist organisation. It is full of speculation and opinion without real foundation as to what other unidentified people, open quote, might do, close quote. Emphasis was also placed on the concluding paragraph of Detective Senior Constable Reason's affidavit, that it should be read as a, open quote, picture of a group that has effectively dissipated, with members being disillusioned and having moved on to different groups, full stop. 82. Fourth, there was nothing in the prior convictions relevant to terrorism or of sufficient seriousness to give any concern about the defendant having potential to commit serious terrorism offence in the future. There's no evidence whatsoever to prove or justify that any terrorism offence was going to take place in the now, Matthew Reason, or in the past. 83. Fifth, there was nothing in the risk assessment report of Miss Prince which could comprise an assessment result of relevance to, quote, terrorism behaviour, end quote, colon. Quote, 113. The notable difficulties in determining the specifics of Mr. Kisconen's risk are further complicated by the limitations of the assessment having not been afforded the opportunity to involve Mr. Kisconen in interview or assessment. Further, whilst the United Kingdom of Australia promotes and adopts the sovereign citizen style beliefs, their overt promotion for violence to achieve sovereignty is not clear. To the knowledge of the author, the United Kingdom of Australia has not been designated as a terrorist organisation. As such, whilst it is evident that Mr. Kisconen has previously taken a leadership role in the group whether his behaviour could constitute a serious terrorism offence is directly related to the fundamental intent of the broader group. If the United Kingdom of Australia was to be designated as a terrorist organisation, he would certainly present a threat regarding directing the activities of a terrorist organisation, Section 102.2. membership of a terrorist organisation, section 102.3, recruiting for a terrorist organisation, section 102.4, training involving a terrorist organisation, section 102.5, getting funds to, for, or for a terrorist organisation, section 102.6, providing support to a terrorist organisation, section 102.7. 114. There is currently no information that suggests that Mr. Kiskonen is or had previously made any preparation toward undertaking or directing others to undertake an act of violent extremism, politically motivated violence, or terrorism activity. However, his statements and promotion of the government officials as, quote, war criminals, quote, foreign occupiers, and Australia currently being an, quote, occupied country, and therefore rules of war applying, are certainly significant expressions of concern. This is furthered by his making statements regarding holding the police, courts, government to account, using them as an example through military jurisdiction, military trials, and noting that some public servants deserve to be hanged and, quote, their necks snapped. He notes it would bring him, quote, pleasure, no, satisfaction. His role as, quote, the face of, quote, the kingdom was him creating and promoting written documents, recruiting and encouraging others to take the oath, promoting the ideology and the imminence of needing to pick a side in order to be afforded protection. Whilst he is not overtly or publicly calling for violence to overthrow the government, he does create and seek environment and a narrative which would easily be interpreted as a, quote, call to arms. 84. At its highest, the conclusions in these paragraphs amount to speculation that the environment or the narrative could change to be interpreted by others as a, quote, call to arms, end quote. There is nothing relevant to activity in custody and nothing that indicates information that any of the defendant's current or former associates are known to be included in terrorism activities. The amount of documents that the police and their mental health unit have put forward in defense of a claim that seems to be, in defense of what seems to be the state protecting itself from something that could be valid at law. 85. In respect of Section 10(I)(c) of the Act, the defendant submitted that neither he nor the UKOA have advocated support for a terrorist act or violent extremism. Section 2 factors must be borne in mind, as must Section 100(I)(a) and its interaction with Section 100(I)(3) of the Code, that effectively excludes certain activities from the definition of, quote, terrorist acts, end quote. 86. There is no evidence that the defendant intended to cause physical harm to any person or endanger lives by his actions. The calling for the curial overthrow of the government does not amount to a, quote, terrorist act, end quote, or a calling for curial punishment. the court should view any statement that a person or class of persons will be punished in a particular way, even by capital punishment when the law is changed, is quintessentially political advocacy, no matter how offensive or uncomfortable those threatened by it might find it. This to me is probably the most important clause in this entire document. It basically lays out exactly what I was saying, and the United Nations knock 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 on the door double confirms everything that I was saying. Definition: curial, adjective, relating to the curia, the papal court at the Vatican, cardinals who hold curial offices. There is a definite hint here at a legitimacy that is taking place, which many of you won't actually see, in that this being named by title in a document, wherein it's also been hinted at that the law isn't with this side, it's with their side, and they're the ones that sipped from that so-called poison chalice, which they were warned about in 1946 so gravely. 87. The court could find that what the defendant is advocating is not conduct in support of violent actions, but rather application of what he believes might be the result of due process of law, and so it is in effect an extreme political view advocating political change as opposed to an extremist view advocating illegal violence. This, held with the previous paragraph, would then tend to lean towards awakening to two sides on a table. 88. The court should take at face value the videos and statements within them that are careful not to invoke extracurrial violence, but telling listeners to be careful of what he had seen to be the operation of law once the matter was before The Hague. He also admonishes people who might attend that they must not be violent. In effect, what the defendant is advocating is for the people to assert their rights, but if you are forced to, go peacefully and keep a diary of the interaction. 89. In respect of section 10(1)(a) generally, the UKOA does not support, quote, terrorist acts, end quote, or, open quote, violent extremism, end quote. It must be borne in mind that UKOA is not a declared terrorist organisation. The court should have real reservations about making a finding that the defendant's conduct meets the statutory threshold. Justice Julia Lonergan is referring to other justices that may oversee this to be wary of the position that is put forward, knowing that there is a viable liability. 90. Whilst the bar at preliminary hearing is a low one, there is still a requirement that the court is satisfied to a high degree of probability that the person poses an unacceptable risk of committing a serious terrorism offence, if not kept under supervision under the order. Section 24(7) of the Act requires the court to dismiss the application if the supporting documentation does not justify the making of an ESO, an extended supervision order. When the matters set out in S25(3) are considered, particularly noting the nature of the type of activity the defendant has actually engaged in, all there is comprises a generalized risk of making offensive YouTube videos and or speculation about what other people might do when they see such material. 91. It is important to note that the defendant would be subject to the parameters of a CTO to manage his mental health issues, which can be renewed as many times as necessary, as well as the Commonwealth Recognizance Release Order in place March 2022. These items have the role of greatly curtailing any risk that the defendant will commit an offence. 92. The current information regarding the defendant is that he is no longer expressing adherence to UKOA philosophy. This should be seen as at least some evidence of decreased risk, regardless of the caution expressed by the treating specialists that he may be stating this to deflect scrutiny. 93. In the respect of the CTO, it was emphasized that this is a coercive mechanism that overrides the defendant's personal autonomy in regard to treatment, including, if necessary, enforced medication, as well as potential changes to his liberty, such as being required to attend particular places at particular times to be examined. It also allows for medication to be given without consent and for further oversight by the MHRT if there is a lack of cooperation with the requirements of the CTO. Police can become involved to detain the defendant and take him to hospital for enforced treatment. This is what Matthew Reason was hoping would happen, given the actions that he's progressed through in a bid to try and get somebody labelled as something they're not, because they may or may not be a threat to the legal position that Matthew Reason believes he stands in. 94. The Commonwealth recognizance was said to also provide a level of supervision in the community. It involves a referral to complete the EQIPS foundational program to address generalized offending behavior, a referral to a psychologist for assessment and implementation of strategies to address, among other things, his mental health and ideologies associated with the UKOA. Referral to the, quote, proactive integrated support model, end quote, of Corrective Services New South Wales, as well as to the CS New South Wales Terrorism High Risk Offenders Unit for offence-specific intervention and to monitor his engagement with community corrections. These things would be more than sufficient to deal with any risk presented by the defendant. So the Justice has pointed out quite a lot of failures on behalf of the state in their fear of this organisation and this jumping the gun to attack it, and then an attempt to undermine the very premise of it with the belief that it has disseminated and people have gone over to other groups. There is a legal precedence that has been put on the table here that the Justice is very well aware of. And that has caused the comments in the previous video in relation to the curial aspect of what it means to be the state. 95. The criminal history comprises relatively minor summary offences. A neighbourhood dispute should not be described as, quote, serious, end quote, in the context of an application for orders based on the potential for terrorism. The presiding magistrate made positive comments regarding the hope that the defendant could return to his family and resume work. He took into account the defendant's mental health issues and tailored the sentence in a way that assisted the defendant to be provided with rehabilitation, to be supervised by community corrections upon his release. Nothing was said by the magistrate suggesting that he thought the defendant was a terrorist risk. Just note the words that are highlighted. 96. The plaintiff's submissions that the defendant's beliefs are commitments support potential engaging in terrorism activities are speculative and rely upon the speculative proposition that the defendant's mental health will deteriorate. This ought not to be the conclusion reached by the court given the CTO. 97. The risk the plaintiff argues is presented by the defendant is also premised on the need for a prior narrative shift to create perceived legitimacy for violence. There is simply no evidence as to when or how that narrative shift would occur, and so really is no material upon which the court could find the circumstances that would underpin the reality of any risk presented by the defendant would occur, let alone it being considered to be an unacceptable risk. In other words, the police are full of shit. 98. The offensive material said to be material that advocates violence and amounts to a, quote, call to arms, end quote, to followers of the UKOA seems to be a somewhat cynical submission, given that there has been no application by the state or police for the defendant's Facebook or YouTube material to be taken down, despite there being various ways this can be done. 99. In an end result, what the plaintiff argues is not that the defendant intends to encourage or foster others to commit a terrorist act. There is no evidence that he holds or has ever held such an intention. The highest the plaintiff's case rises is that his videos might, underlined, lead some people to commit terrorist acts. This has to remain an uncalculated, unevidenced, speculative risk which cannot, on any analysis, satisfy the court to a high degree of probability that the defendant poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order. 100. Even if the court thought the test was satisfied, the court should decline to make the order on discretionary grounds, given the role of the CTO and the Commonwealth recognizance that will both run to control any risk presented by the defendant. Section 25(3), Mandatory Factors to Consider. 101. Division 2.4 of the Act sets out the requirements for determination of an application for an ESO. Section 25I provides that the court can determine an application by making the order or dismissing the application. Section 25I provides that the court can determine an application by making the order or dismissing the application. 102. Critically, Section 25(2) provides that in determining whether or not to make an ESO, the safety of the community must be the paramount consideration of the Supreme Court. Section 103. Section 25(3) sets out the matters to which the court must have regard. At this preliminary hearing stage, some of the parameters have not yet been the subject of evidence. For example, there are no reports from persons appointed by the court to conduct psychiatric or psychological examinations of the offender. And most unfortunately, the risk assessment report by Miss Prince, prepared late June 2021, did not include any interface at all with the defendant, so revelation of his current stated thoughts and plans are limited to the 22 June 2021 review by Dr. White set out in 48 of this judgment. 104. To the extent that there is material available addressing these mandatory matters, I will refer to it at the level of detail I consider critical to my determination of this application. Given the very short turnaround time required of this judgment, not every aspect of all the 1,500 plus pages of material tendered can be the subject of reference or comment. Section 25(3)(b) assessments of psychiatrists, psychologists, or medical practitioners as to the likelihood of the offender committing a serious terrorism offence and his cooperation with assessment. 105. Whilst it is clear that the court must take the evidence relied upon by the plaintiff at its highest, the report of Miss Prince is heavily qualified. On more than 10 occasions within the report, she makes reference to the fact that she had not had an opportunity to engage with the defendant, and so in a number of respects she declines to express a view about aspects of the potential risk that he presents. 106. The reason why the defendant was not made available to her to interview remains unexplained, despite my invitation to Mr. Emmett to explain why the defendant was not interviewed for the report. 107. From the conclusions expressed in the, quote, executive summary, end quote, it is evident that Miss Prince based her assessment on a file review only, but rather than simply allowing that fact to speak for itself, Miss Prince goes on to say that her report, open quote, should be considered an interim assessment only. Mr. K should be engaged in interview, underlined, to allow for a more informed assessment of his current vulnerability, risk profile, and protective factors, end underline, end quote, emphasis added. This is the justice adding emphasis to the amount of action that has been stacked up against the defendant and the fact that it is spurious and very uncalculated and far too numerous to address. 108. Miss Prince concluded, quote, Mr. K is currently assessed as moderate to high risk for politically motivated violence, violent extremism, or terrorist activities using the VERA 2R. His role would likely be one of a promotion, recruitment, and development of materials which promote the cause. when he would directly or indirectly promote the use of violence to achieve his goals is unclear. However, the emotive language and rhetoric is a genuine possibility to be interpreted as a call to arms. Mr. K's risk of grievance-fueled or targeted violence was assessed with the TRAP 18. This assessment suggests that monitoring and active case management is warranted. This would be best achieved through the application of an ESO with the joint management by the New South Wales High Risk Terrorism Offenders Team and the Community Corrections Terrorism High Risk Offenders. Details of recommended intervention and management strategies are outlined at the end of this report. Now, what should alarm most viewers is the word VERA, the Violent Extremism or Terrorism Activities Mental Health Assessment Tool. And this then goes again for TRAP, T-R-A-P. The targeted violence was assessed with TRAP 18. So these are two tools that they try and box you in with. This is, are you a left or a right? Well, I'm a left. Okay, well, we'll box you in that way then. Are you a Z or a B? Well, I'll box you further in that way then. That's what they've done. And it's very evident by the evidence that's been put on the court record by Justice Julia Lonergan. 109. In terms of the risk assessment process, Ms. Prince noted that it is not scientifically possible to accurately predict whether or not an individual offender will or will not reoffend, and that the best that can be offered is an, quote, estimate that is anchored to empirical literature specifying features associated with risk and sound clinical analysis and formulation of how those present features might operate in the individual subject to the assessment, end quote. She explained that process of risk assessment of violent extremism or politically motivated violence is, quote, comparatively new, end quote. When compared to the risk assessment for general violent and sexual offending behaviours, she explained that the assessment of risk of violent extremism, quote, cannot be anchored in the statistical probabilities and subsequently a numerical score cannot be provided. Rather, the overall risk judgment is based on the clinician's assessment of the available information at the time of the assessment, end quote. 110. The VERA that Ms. Prince performed was completed on file information only, and again, Ms. Prince noted in that context, open quote, it is recognised that this should be considered an interim assessment only, close quote, and again says, open quote, ... Should the opportunity to interview Mr. K avail itself, it is strongly recommended to be invited to participate in interview and assessment, close quote, invitation. She then goes on to state, based on the assessment of all the available information that, open quote, he is currently assessed as moderate to high risk regarding violent extremism, politically motivated violence, or terrorism activity, close quote. She makes this assessment without ever making any inquiry herself as the defendant as to whether any of the views in issue are currently held by him. So this doctor has made a Vera report assessment based on documented evidence and no physical interview with the defendant whatsoever, therefore determining through the documented evidence that he may be a risk to the state. That's all it is you've become a threat to the state, and they're going to bring out the tar and the feathers, and they're going to make sure that they get away with their crimes. That's all this is. 111. Miss Prince stated, obviously based on the observations of others, that, open quote, his actions thus far have demonstrated his ability to have significant influence through both social media platforms and in real life. He has demonstrated a willingness and ability to recruit others to the cause. He has dedicated all his time outside of work on promoting and supporting the kingdom and detaching from his family. It has had a notable impact on his mental health and his liberty, with his being incarcerated for both a breach of his community corrections order and his index offences. 112. Miss Prince concluded, without really explaining why, that there is a, quote, likelihood, end quote, that the defendant has maintained his belief in the cause and in, open quote, Stephen, close quote, and so, open quote, it is likely that should he be released without any active monitoring case management, he will likely resume his role, close quote. She added again, without explaining why, that, open quote, whilst residing with his wife and the recognizance order may provide some level of protection in the immediacy, this is likely to have a limited long-term effects, close quote. 113. Somewhat contradictorially, Miss Prince says this, open quote, 124. The impact that Mr. K's incarceration has had on his worldviews is unknown. Whilst incarceration and medication appear to be a significant deterrent, whether he has the will or ability to cease all contact with, quote, the kingdom remains unknown at this time. This is likely further complicated by the potential for Mr. K's more recent experience through his contact with police, the courts, and the mental health services that may have potential to influence an increase in personal grievances which aligns with the greater cause, close quote. Reference 6, Confidential Interim Psychological Risk Assessment Report dated 30 June 2021 at paragraph 124, demonstrating that Her Honour Justice Julia Lonergan has chosen very specifically to document this on the court record. A deterrent. The drugging was used as a deterrent to stop him from having beliefs in something that may put the state into an accountability mode. 114. I consider the first part of paragraph 124 to be a reasonable reflection of the reality, that is, that it remains unknown whether the defendant has or will cease contact with the, open quote, the kingdom, close quote, or not. The second part of the paragraph amounts to nothing more than speculation. 115. With respect to the author, who is not given the opportunity to review and assess the defendant, the report contains much repetition of the comments of others, many assumptions, and much speculation. Even at this preliminary phase, and taken at its highest, the report carries little persuasive weight in assisting the court to resolve whether the defendant presents a relevant risk of committing a serious terrorism offence. Section 25(3)(d). Any report prepared by Corrective Services New South Wales or the New South Wales Police Force as to the extent to which the offender can reasonably and practically be managed in the community. What I'd like you all to recognise up until this point is the amount of doctors' names that are involved with something so out of the normal. It is so unusual the way that the defendant has been treated, and it's not the first time this has happened to someone, but it demonstrates the amount of attack that's put in. But at the same time, it's almost like all these doctors are dipping in the bucket, wanting a part of that payment system. 116. The report of Mr. Bagley adds little to the question of risk, other than setting out and advocating his views as to how the defendant can be managed in the community and why he sees the multiplicity of proposed conditions to be necessary. The HRTO Unit Management Report of Detective Sergeant James is in the same category. Section 25(3)(g). Options, if any, available if the offender is in the community, whether or not supervision that might reduce the likelihood of him reoffending over time. 117. I accept the submissions of the defendant in the respect of the potential role of the CTO in managing the risk of relevant offending. I consider the recognizance to have a lesser role given it will expire in March 2022, and it cannot be renewed, but it has some role potentially in reducing the likelihood he will relevantly offend. Section 25(3)(h). The likelihood that the offender will comply with the obligations of an ESO. Section 25(3)(i). Previous compliance with obligations under parole conditions. 118. The defendant failed to comply with his previous CCO. His failure was tied to his beliefs that were entrenched, it seems, at the time. It is hard to predict whether the defendant would comply with the proposed demanding combination of conditions proposed for the ISO and potential future ESO. He may, but the real question is whether there is a proper statutory basis to impose them. Section 25(3)(j). The offender's criminal history, including prior convictions and finding of guilt in respect of offences committed in New South Wales or elsewhere, and any pattern of offending behaviour disclosed by that history. 119. There is, in my view, no relevant previous pattern of criminal offending. Section 25(3)(k). The views of the sentencing court at the time the sentence of imprisonment was imposed on the offender. 120. I agree with the submissions of the defendant that the defendant was not dealt with as a, open quote, terrorism close quote, offender, nor were the charges levelled against him framed as terrorist offences under the Code. Section 25(3)(l). Beliefs or commitments of the offender, whether of an ideological, religious, political, social, or other nature, that support engaging or participating in terrorism activities. As we move forward, just bear in mind the subject matter of the mind that we mentioned earlier, and how this was all about a belief, and what belief would be fact or truth, and what would be indoctrination being force-fed to you. 121. There is no doubt that in the past the defendant engaged in and professed beliefs of an ideological nature subscribed to by the UKOA. There is a lack of contemporaneous information as to whether he in fact still subscribes to these beliefs or not. It is at least possible that the ongoing treatment of his mental illness with medication has led to a recalibration of his delusions and previously fixed belief system. Imprisonment has also had a role. At the time of the assessment by Dr. White in June 2021, the defendant said he did not believe those things anymore. Dr. White reported no cynicism about that assertion, and there is no current evidence adduced by the plaintiff that demonstrates a contrary position. Am I satisfied to a high degree of probability that the offender poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order? 122. It seems to me that the requirements of subsection 20A and B of the Act have been met. I entertain some doubt that section 20C has been met, but I consider it just made out on a revisionary and reconstructed analysis that because some of the identified past activities of the defendant, with hindsight, he could be viewed as a, open quote, convicted New South Wales terrorism activity offender, close quote. 123. However, I do not accept that there is a high degree of probability that the defendant poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order. 124. The evidence taken at its highest is equivocal as to where the defendant currently stands regarding his beliefs or otherwise in the doctrines of the UKOA. 125. There are multiple layers of speculation involved in the material upon which the plaintiff relies to reach the proposed conclusion as to the defendant's relevant risk. 126. I also doubt that the type of activities the defendant might engage in, even if he was still a, quote, believer, end quote, would, properly considered, amount to a, open quote, serious terrorism offence, close quote. So we can see this want to further impact onto the defendant has been quashed, it's stopped. And we also see that the justice uses some words in 126. I also doubt that the type of activities the defendant might engage in, even if he was still a, open quote, believer, close quote, would properly considered amount to a serious terrorism offence. Believer, belief, beliefs. And we get back to delusion, delusional beliefs, recalibration of his delusions, did not believe those things anymore, used drugs to stop him from believing those things as an intervention. So this key remark on belief at the end by the justice is directly relevant to the whole entire case, in that what's the whole reason that he was incarcerated and put under these duresses in the first place were because of his beliefs. But why was he treated in this manner by all of these doctors if it's all right to have those beliefs, and that the United Kingdom of Australia, in the blessing of Almighty God, is not a terrorist organisation, and with its curial opposition therefore cannot be defined as a terrorist organisation? I can't stress this enough. The United Nations came to New South Wales and said, let me in, and New South Wales said, no, we don't want to let you in, and the United Nations requested through the federal government and then left. This is important because now, on the books, New South Wales have demonstrated that it don't want to play by international rules. And now they've been put in the hot seat by their very own actions and the actions of their New South Wales police. These agents, doctors, police officers, and in many ways the Justice Department have created this situation, and the Attorney General of New South Wales has a bit of an issue on his hands in relation to this situation, given that what I've laid out, without shadow of a doubt, falls directly under Rule 92. That's the unfortunate truth of the matter, is that what befalls the Attorney General of New South Wales right now, asides all other claims, is that what you see before you falls under Rule 92 of the international humanitarian law. You can't escape that fact. 127. Fundamentally, however, I dismiss the plaintiff's amended summons because I am not satisfied to the requisite high degree of probability about the risk the defendant poses, and I cannot conclude that he represents an, open quote, unacceptable risk, close quote, of committing a serious terrorism offence if not kept under supervision under the proposed ISO or ESO. Orders 128. I make the following orders. 1. Amended summons dismissed. 2. Plaintiff to pay the defendant's costs. So we can see this want to further impact onto the defendant has been quashed, it's stopped. We also see that the justice uses some words in 126. I also doubt that the type of activities the defendant might engage in, even if he was still a, open quote, believer, close quote, would properly considered amount to a serious terrorism offence. Believer, belief, beliefs. And we get back to delusion, delusional beliefs, recalibration of his delusions, did not believe those things anymore, used drugs to stop him from believing those things as an intervention. There is so much in this document that points to not only torture at a technical level, but we go beyond torture into forced medical procedure. We go into medical intervention and some seriously nasty connections to forensic psychology and the justice system. It could be said that forensic psychology should be shut down. It's quackery. It could also be said that forensic mental health within those jail systems should be shut down, and all of that health should be brought under the auspices of the Department of Health of New South Wales, and all those prisoners should be treated exactly the same, with the same responsibilities and liabilities of Health New South Wales. What can be seen here is a direct issue that reflects why the Attorney General of New South Wales is in the back foot in response to the United Nations inspectors coming to visit New South Wales facilities, corrections facilities in particular, wherein these forensic mental health facilities exist, because they don't exist in the hospitals, or they might within the boundaries of those mental health doorways, but in general they don't exist under the Department of Health. There is an overly serious offence that has been committed here, and it needs to be addressed, because this is happening to people every single day. This is happening to people every single day. It's when the justice is leaving these trails of evidence on the table, it's being done for a specific reason, in that what is not a mental health problem becomes a mental health problem because of the sheer intervention by these forensic mental health agents. That they have made up the quackery, and in some of these occasions made up this quackery just based upon paper reports. So having no physical interaction or legal discussion with any of them. And what can be proven here is there is a grave ignorance in many of these doctors. It's easier to shut up than have to answer to all of this stuff, because they don't want to listen to your answers. That's a sad truth. And that they can't deny this, because they put me through exactly the same thing for being in a jail over recording in a courtroom. And no civil libertarians stood up then. No one said, "Hey, what's going on? Why would he be doing that? Why is he going to jail for that?" No one looked at anything back then. And here you have a justice, in the justice's words, stating the type of activities believer, not terrorist, not terrorism activity, Curial versus something else. This puts them in a position which would bring something else to the fore. Right, this sort of closes the documents at the end notes, and then at the final end of the page there are some referenced citations. These are the court cases that were referenced within the text above. Legislation cited by this decision: the Constitution of Australia, 1 citation. The Criminal Code Act 1995, Commonwealth, 11 citations. Firearms Act 1996, New South Wales, 1 citation. Terrorism High Risk Offenders Act 2017, New South Wales, 37 citations. Note, New South Wales, 1 citation. So all the other citations to all the other acts, and this one act has 37 citations. I can't stress this enough. The United Nations came to New South Wales and said, "Let me in," and New South Wales said, "No, we don't want to let you in," and the United Nations requested through the federal government and then left. This is important because now, on the books, New South Wales have demonstrated that it don't want to play by international rules. And now they've been put in the hot seat by their very own actions and the actions of their New South Wales police. Well, I can't stress that enough. It's all in front of you. These agents, doctors, police officers, and in many ways the Justice Department have created this situation, and the Attorney General of New South Wales has a bit of an issue on his hands in relation to this situation, given that what I've laid out, without shadow of a doubt, is a deterrent. The drugging was used as a deterrent to stop him from having beliefs in something that may put the state into an accountability mode.
There he is. Where? There. What, behind the rabbit? It is the rabbit. You silly sod. What? You got us all worked up. Well, that's no ordinary rabbit. That's the most foul, cruel and bad-tempered rodent you ever set eyes on.
You tit! I saw my arm and I was so scared.
Look, that rabbit's got a vicious streak a mile wide. It's a killer.
Get stuffed.
He'll do you a treat, mate.
Oh, yeah? Manky Scots git.
I'm warning you.
What's he do? Nibble your bum?
He's got huge, sharp... he can leap about... Look at the bones!
The United Nations decided they can't be bothered with China and Iran and Venezuela,
North Korea.
Why bother with that? Let's go to Queanbeyan and check out the torture cells that are occurring. Queanbeyan. So the United Nations rocked up to Queanbeyan, and the Queanbeyan jail said, "No thanks.
Yeah, well,
you're not in. You haven't made an appointment." you're not in.
So what happens is, because Australia is a party to this Commission on the Prevention of Torture or something like that, they sent these inspectors around to rock up unannounced. Well, the Perrottet government said, no, you're not coming into our jails just unannounced, because you know that with all of these sorts of things, we know historically that Australia always cops it from the UN. There was a great report that UN Watch out of Geneva just did about Michelle Bachelet, the outgoing human rights commissioner, and she criticized personally North Korea as many times as she criticized Australia. So the UN are not honest brokers, and you would not want them anywhere near, because they'd say, if you look at the cells, the toilet paper was hung in the wrong direction. That's a human rights violation.
Racism,
but not a serious
sexism.
note.
We're going to show you a scene from another film and ask you to guess where the fish is. But if you think you know, don't keep it to yourselves. Yell out so that all the cinema can hear you. So here we are with Find the Fish.
They could do some good in Victoria, because
They could.
have a women's
Well, we were
prison.
saying North Korea, Iran, Venezuela, Victoria.
Victoria,
They're all lumped together.
Well, we have the biggest women's prison in Victoria that has at the moment an inmate who is born male, now identifies as female, but still has a male body functioning bits. And this is not just any sort of prisoner, one with a terrible track record, a sexual predator. And the women in that prison don't feel safe. They have put a petition together. They have tried to get the authorities to do something about this. And I know there are a group of women who are hoping that the UN actually does some good during this visit to Australia and says that human rights of these women is being infringed upon in the interest of this male predator. We'll see if that happens.
That would be fantastic. I wouldn't hold my breath. But the United Nations is, as we'll be talking about later, is not exactly on the side of, well, anyway.
Logic and common sense.
Look! Jesus Christ! I warned you.
I've done it again.
I warned you, but did you listen to me? Oh, no, you knew it all, didn't you? Oh, it's just a harmless little bunny, isn't it? Well, it's always the same. I always tell them, do they listen to...
After it like a son, and it went wherever it did go. Is it in the cupboard? Yes. Wouldn't you like to know? It was a lovely little fish, and it went wherever I did go. It's on the sofa. Where can that fish be? Have you thought of the drawers in the bureau? It is the most elusive fish, and it went wherever I did go. Oh, fishy, 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 fish. A fish, a fish, a fish, a fishy, oh. Oh, fishy, 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 fish. That went wherever I.
126. I also doubt that the type of activities the defendant might engage in, even if he was still a, quote, believer, end quote, would, properly considered, amount to a, open quote, serious terrorism offence, close quote.
I am you, and you are me. Why's that such a mystery? If you want it, you got to believe. Who are we? We're who we are. Riding on this creepy star. We got to stand up if we're gonna be free, yeah. If you want it, you got it. You just got to believe. Believe in yourself. 'Cause it's all just a game. We just want to be loved.
So this key remark on belief at the end by the justice This is directly relevant to the whole entire case, in that what's the whole reason that he was incarcerated and put under these duresses in the first place were because of his beliefs.
They haven't said much about the meaning of life so far, have they?
Well, it's been building up to it.
Has it?
Yeah, I expect they'll get onto it now.
Personally, I very much doubt if they're going to say anything about the meaning of life at all.
Oh, come on, they've got to say something.
They're bound to.
Yeah.
So when we now consider the Attorney General's response to the United Nations, we must then now address the Attorney General of Australia and the planning put in by the state in relation to a perceived threat to the state, which at law might demonstrate very clearly a false perception definitely laid out in evidence by Matthew Reason and the Fixated Persons Unit, demonstrating very clearly of not only the ignorance of the subject matter involved, but the sheer fixation on stopping anybody that sought to bring said subject matter to light. The sheer premise that the state can then indoctrinate you with doctrine that it believes to be true, that is in fact completely false, and so much so that it could be considered a severe abuse of international treaties and conventions, such as the right to family and the right of religion. This would also take into account, which would have allowed all of these jurisdictions to exist in the first place, therefore allowing all of these facilities to have a presence. There is a line of authority that is left to hold what is God's, which would then determine the use of the fruits. This then doesn't escape the fact that human rights abuses have taken place, which would then be construed as international war crimes that have taken place.
I wonder where that fish has gone.
You did love it so. You looked after it like a son.
And it went wherever I did go.
Is it in the cupboard? Wouldn't you like to know? It was a lovely little fish.
And it went wherever I did go.